Good morning, everyone. Give us a second here to get situated. Good morning, everyone, and welcome to our case call this morning. As you heard, I'm Christopher Trabilcock. I'll be sitting in as a presiding judge today. I'm joined by my colleagues, Judge Cameron, and our newest colleague, Judge Andrew Levency, who was just recently appointed. I've known Judge Levency for over 25 years, and it is indeed my personal honor to welcome him to his first day of case call. So welcome, Andrew. I have no doubt that he will become a valued member of this court and that Michigan's justice system will benefit from your experience and dedication. So on behalf of the rest of our bench and Judge Cameron, welcome and congratulations to your appointment.
Thank you for your comments.
Again, to our frequent flyers and those who you may be experiencing the Court of Appeals for the first time, welcome to our first day of our May 26th Detroit case call panel number 3. For everyone's benefit here in the courtroom, I do have a few initial comments for everyone. First, we recognize that these cases are important to both litigants and counsel. Often our decisions are the final word on the dispute or problem that gives rise to each case. I can assure you that we have been diligently working on each case called today, and we've had the benefit of your briefing in our preparations for today. Now, we have a very full schedule, so I do want to cover just some basic ground rules so everybody's on the same page. First, each party is allotted for time for oral argument in accordance with the court rules. We'll do our best to keep track of that time up here and let you know where you stand for that. Second, if there's more than one attorney who is arguing for a side, please let me know how you plan on dividing your time at the outset. Third, for the appellant, let me know at the beginning if you'd like to reserve time for rebuttal, and I'll make sure that we reserve time for that. And the fourth and final rule is that if your case involves children, sexual assault, or other sensitive topics, please do not mention the parties or the children's names. Instead, refer to them by initials or private identifiers. We will be trying and do our best to remind you of that, but this is a recorded public hearing and it will be posted later today or overnight on YouTube and is available for public viewing. So please, again, be mindful of privacy concerns. My last comment before we call the first case is my advice based on over 24 years of practice before this court and my time on the bench. And my advice is this. We are very familiar with the relevant facts and pertinent case law. We have had your briefs for many weeks now. Please do not repeat what you've already said in your briefs. We've read them. Our clerks have read them. I highly recommend you focus your limited time on the specific issues that are dispositive to your case and to address any questions that the bench may have. If we're asking a question, it's because it matters to us and may be outcome determinative. So please focus that, and we look forward to having a lively discussion here today. With that, we will call our first case, item number 377838, People v. Holland. You may approach.
Good morning, Your Honors. May it please the court. Melissa Krauskopf on behalf of Mr. Holland, who is the appellant in this matter. I don't typically say a whole lot at oral argument. I'm going to say just a little bit more here today than I normally would. This is a somewhat unusual position for me because I'm also trial counsel in this case, and that honestly doesn't happen very often. Normally, when I'm standing up here, I've handled the appellate portion of it only. But I can tell your honors that I have lived with this case since June of 2024. And since basically the day that I was appointed on this matter, the conversation that I had with the assistant prosecutor was, how are you going to proceed? How is it that we are going to proceed on this case? Because in my mind, you can't. There's no way that this case can proceed to trial. And so I think the record is clear that when this matter was bound over after exam, it was bound over on 27C statements, which everyone is in agreement cannot be used at trial. The people here are asking that this court read an exception into the law that A, doesn't exist, and B, taken to what I think could be its very likely conclusion, would negate the need for the people to ever call a victim or complainant in a domestic violence case to testify. I will note that the majority of the cases, actually all of the cases.
Does it matter, counsel, does it matter that the statements were made for purposes of the rule by a victim of domestic violence? Aren't you suggesting that the rule then is different for domestic violence? Isn't the real look on whether under the rule, the exception under 803 is whether or not the questions by the medical personnel were reasonably necessary for medical treatment? Isn't that what we focus on? And it doesn't matter whether it's the domestic violence victim or somebody who was in a car crash or somebody who was a victim of some other crime. It could have been an elderly person who was found at their house a week later at the bottom of the stairs. The medical personnel shows up and asks the person, "Hey, what happened? How did this happen? Why are you laying here?"
Yes, Your Honor, you know what? I agree with that. It's the people who are asking that this court read an exception in for domestic violence victims. In other words, that there's something special and unique about domestic violence cases that means we can ignore the rules of People v. Lalone and the general law that the identity of the perpetrator is not necessary, not reasonably necessary for medical diagnosis and medical treatment.
So let's dig into that issue on terms of the identity of the perpetrator. Is your issue with that she said, "Look, my boyfriend pushed me down the stairs," or is there a difference between, "Hey, my boyfriend pushed me down the stairs," and Jack Smith pushed me down the stairs?
So I guess my answer to that is twofold. One, I don't think there's a functional difference, at least not in this case, because what the people are attempting to do here is use this statement to establish the identity of the perpetrator because they don't have a complainant who's going to come in and say either my boyfriend or Robert. So I don't think there's a functional difference between the two for purposes of Lavone. I don't think there's a functional difference.
So she would have said, a Caucasian male, 6'2", in a gray hoodie pushed me down the stairs, and that's how I cracked my head to the medical personnel. Would any of that come in?
I don't think so. Not unless the identity of that person, however that person was described, was reasonably necessary for medical diagnosis and treatment. I would also note that we don't actually know what she told the paramedic or the emergency room doctor because the only testimony we have was from the detective at the preliminary exam who was repeating what the emergency room doctor and the paramedic had told him.
Is that addressed in your briefing? Because that seems to be a double hearsay issue you're talking about. Is that addressed in your briefing?
It is addressed in my briefing. I did address the fact that there was no testimony from anyone other than Detective Macklin at the exam as to what was said. And I think, if I recall correctly, when I filed the motion to dismiss in circuit court, I may have asked for an evidentiary hearing in the alternative, but at any rate, the circuit court judge decided this issue without further hearing. So he decided it, the trial court decided it based on the preliminary exam transcript.
So you filed a motion to quash and an evidentiary hearing for purposes of trial and a motion to eliminate?
I filed a motion to dismiss or exclude hearsay statements.
So you did not file a motion to quash?
No, Your Honor, I did not because the case was bound over on 27C statements. So the way the case was bound over was not a confrontation issue at exam because the case was bound over based on the complainant's statements to law enforcement, which we then, because these specific statements to the paramedic.
Let me
and-
just interrupt you for a minute. I understand what you're saying, but a motion to quash, that would be sent back, the remedy would be sent back to district court. But you didn't file that. Instead, you filed as a matter of law, they can't proceed. And I think your point you're trying to make, or you're making, is that the trial court relied on, in making its ruling, double hearsay.
Yes, Your Honor.
Okay.
Yes.
Following up on a question that was asked earlier, what about if, I know this is still, the identity is the issue, I understand it. But would you agree that the statement in response to the question, how were you injured, the response, I was pushed down the stairs. Would you agree that that is admissible? I don't think that gets the prosecutor where it needs to be. I understand that, but I want to understand the scope of what you're saying.
Yes, I would agree that for purposes of 803-4, that could reasonably construed as a statement made for purposes of medical diagnosis or treatment.
Thank you.
Counsel, would you agree that Michigan case law provides a rebuttable presumption that statements made by people over 10 are generally trustworthy to medical personnel?
I would agree with that.
Okay.
I would agree with that. So my dispute is not statements coming in for medical purposes. My dispute is that the law holds that the identity of the perpetrator is not generally necessary for purposes of medical diagnosis or treatment.
So help me understand the lower court. What's your issue then? Because didn't the lower court put some guardrails on what statements could come in and said you couldn't, the EMT and the ER doc wouldn't be able to testify as to the specific identity?
Correct. So
Why is that not the correct solution then, to follow up on Judge Cameron's issue? If we don't have an issue of saying, hey, I was pushed down the stairs, that's how I have this bruising all over me. That's okay, but you can't say it was, Jack Smith that pushed me down.
Because the way the exception reads or the way the law reads is identity, it's not name. And so what the trial court ruled was that the emergency room doctor and the paramedic could testify as to the identity of the perpetrator, but not his name.
Is the focus of the rule on the questions asked or the answers given?
I think it's probably both. I mean, I think, and I think this is probably also all fact driven, right? That if you have different sets of questions and answers, perhaps you have a different response depending on what's covered by the rule. But here again, we truthfully don't know what exactly she was asked and what exactly she said. We have a parroting from the detective of what he was told by the ER doctor and by the paramedic. I don't know why those witnesses weren't called for exam.
I would agree with you on that last statement. I guess my question is trying to drive to the purpose of the rule. It seems to me some of our case law has said that even if the identity is revealed in questioning by medical personnel, that can still come in if the facts and circumstances indicate that the statement was trustworthy. And so I guess my question is, look, this is an abuse of discretion standard, a very deferential lens we're looking through. And if you say, look, you've got a presumption that the person making the statement to the EMS and the emergency room doctor was over the age of 10, so it's presumptuously trustworthy because they're intended not to lie, that, at least they were, this person's being rushed to the hospital because whoever was called 911 because the person was yellow and coming in and out of consciousness. Why is that not inherently trustworthy? And the EMS and the emergency room doctor are basically like, hey, what happened? How are you, what has happened recently that could be causing you to present this way in our ER? Is that not inherently trustworthy, so that whatever statements the person, the victim, the alleged victim made are admissible? They meet that general purpose of the test. They're made under facts and circumstances that are inherently trustworthy such that the hearsay rule doesn't apply.
Because the identity of the assailant, which again, and so I guess I'm not disputing that one could introduce testimony that she said she was pushed down the stairs or she fell or whatever the situation was. I'm not arguing that. My point is very limited to under People versus Lalone, the identity of the assailant is not something that is generally reasonably necessary for medical diagnosis or treatment. That's the state of the law. And there aren't, the only exceptions that have been discussed in regard to this are tender years cases and sexual assault cases. And also,
Go ahead, Counsel. I'm sorry
Your
for cutting you
Honor.
off. Go
And
ahead.
I was just gonna say this, this is a unique set of circumstances, right? This is a unique factual circumstance because most of the cases cited by the people in reference to adults, those witnesses testified at some point, either at preliminary exam, at a trial, so they could be cross-examined. And so when I say here that this, if this, under these particular facts is allowed, the exception is going to swallow the rule, and it puts me, I guess, since I'm trial counsel, in a nearly impossible position because you are now introducing testimony essentially from a witness who has never been cross-examined and can never be cross-examined. And so
Can I
that
ask you
was-
this? Judge Wilcox, correct that the origin of the hearsay exception is the general trustworthiness of statements to doctors, but that's always been true. Mebor actually required trial courts to still, despite that background, go through and address a series of factors, did it not?
It did,
And
for the
did the
children,
trial court
yes.
do that here?
No,
Okay. Secondly, with respect to the reasonably necessary, I think there is a distinction between identity, whether by name or relation or the neighbor or whatever, and so it's not really about the question or the answer given, the question by the doctor or the answer by the person seeking medical treatment. Hearsay gets to what's allowed in court. And so even if the person had said, my boyfriend pushed me down the stairs, that doesn't make that statement, I guess I would say, admissible, because you still have to ask yourself what's admissible under the hearsay exception. Am I right?
I would 100% agree with that,
And the
yes.
question you're asking us to wrestle with is whether the identity is necessary, whether directly or indirectly, to the cause of the injury.
Yes, Your Honor, because that's the only way it comes in here. Absent that statement coming in under the medical treatment exception, it doesn't come in and the people can't try this case.
But doesn't it get back to, I mean, the lower court's ruling said the identity can't come in, isn't, do I understand the record correctly in that?
The trial court's ruling was that the name, it was a little
The
oddly
name
written, but
couldn't come
the
in,
name-
but
the
she
name
could say
couldn't
like,
come
my
in-
boyfriend pushed me down the
correct, the name
stairs.
couldn't come in from those two witnesses. So there is nothing preventing the people from calling victim's mom or whomever to say, do you have personal knowledge of who her boyfriend was? Sure, it's Robert. So, and to me, in this context, under this case law, identity and name are the same. It's the same concept.
Does it matter what the injury is? And does it matter what the doctor might say about whether identity mattered? Because I think you acknowledge that in the domestic violence context, there is that carve out because courts have found that the identity does potentially matter. Excuse me, not domestic violence, sexual assault context. My apologies. That identity may matter. Here, does it matter what, say, the doctor or EMT could potentially get on the stand and say, well, the reason why the identity matters here is this. But is that more case by case, or is that?
I think that's more case by case. I think that would be determined by the facts, which we don't have
And you are
here.
struggling, and as I was, because we actually don't know what the doctor or EMT would say because they didn't testify because there was no trial.
Yes, that's correct, Your Honor, and they were not called at exam. Does the court have any other questions for me? Okay. Thank you, Your Honors.
Good morning, Your Honors. May it please the court, Joseph Shada on behalf of the people In order to avoid redundancy, I'm going to primarily rely on the brief and just highlight and emphasize a couple quick points. The Michigan Supreme Court's reasoning in Mebor has been applied in the context of child sexual assault victims, adult sexual assault victims, and more recently to child victims of domestic, non-sexual physical abuse. And there's no principled basis why this reasoning should not also apply to adult victims of domestic, non-sexual physical abuse.
That last one you're referring to, Jones?
Correct. In addition, the medical community itself identifies and views the identity of a domestic abuser as reasonably necessary for medical treatment and diagnosis. And this court should too. And with those overarching points, I'd be happy to answer any questions.
Expand on your last point, if you could, about the reasonable necessary. I know in the cases involving sexual assault, it's talked about, for STD testing, protection against further, like you don't want to release a child back into an abusive home. Help us understand why those same circumstances may be present with a domestic violence victim where, let's say this woman recovered and the abusive boyfriend shows up and says, release her to my care, or a husband. Is that why that's important, or help me understand that?
Certainly, and picking up with that last point right there, similar to the logic and reasoning explained in Mebor, that there needs to be that opportunity to heal. And if one is returning to an abusive environment, then there is no opportunity to heal. In addition, as Mebor explained, there's a medical, physical, and psychological component to different injuries. And that in that context, it was sexual assault, but the medical, physical, and psychological components are also present in domestic violence injuries. It's often why victims stick around, is because there are these abusive environments and there isn't that opportunity to fully heal and I guess free oneself from that. But as cited in the people's brief, the medical community screens for domestic violence, asks these types of questions because it is reasonably necessary for proper and whole medical diagnosis and treatment.
Is it to, I don't know, refer them to other outside resources, like you're from Oakland County, like Haven?
Absolutely, Your Honor. Yes. Yes. Referral to additional resources and fully, and I guess overall, the big picture would be to fully treat the injury, not just the physical injury, but the psychological components as well.
Counsel, would you agree that in Jones, the trial court considered the Mebor factors for purposes of trustworthiness?
Yes, the trial court did. And in that case, it was a young juvenile.
Yes, and did you note that the Court of Appeals described their analysis as particularly unsatisfactory
Correct.
and considered it a close question as to its analysis?
Correct.
Okay.
In terms
Let
of
me just
those,
ask you though, would you agree that the trial court here did not conduct any of the analysis required under Mebor for trustworthiness? As I asked your co-counsel or opposing counsel.
yeah, the trial court did not consider those factors that are traditionally considered for juveniles.
No, under Mebor. For trustworthiness
Yes.
under the exception.
And under Garland, this court has stated there's a presumption for trustworthiness for the adults.
But didn't consider the Mebor factors. Okay. And would you agree that kids are different than adults when it comes to releasing a kid to an adult and a custodial parent is different than releasing a adult who wouldn't necessarily go back with a boyfriend or husband or whatever else? They're different.
There are differences, but there's also similarities.
Sure.
We heard earlier, the trial court sort of split the baby in terms of identity, not allowing the name, but instead allowing boyfriend. Was the trial court right in splitting the issue like that?
I think that that decision was within the range of reasonable and principled outcomes, because the pertinent question in any case is whether identity is reasonably necessary for medical treatment. And in some cases, the relationship might be what's reasonably necessary for medical treatment and diagnosis. In other cases, the name might be what's reasonably necessary. Take, for example, the sexual assault cases. In those types of cases, there might not be that sort of relationship, but the identity of that person by name might be reasonably necessary for things like STD testing and those sorts.
So
But
you mentioned STD testing, you mentioned imbalance of power, why victims sometimes stay around. That's sort of the traditional domestic violence issue that immediately comes to mind. What about if these were two 30-year-old brothers who were roommates? Same answer?
I think that would be, I mean,
That's domestic.
it is domestic, yes, and it would depend on the facts and circumstances
Okay.
of,
Go ahead.
I was going to say of the case, the injury, of everything, totality of the circumstances, if you will.
So the nature of the injuries, so the same situation you're saying may come out differently if they were brothers?
Depending on the relationship, the injury, it would matter, because, for example, one of the concerns is returning to an abusive environment. If there was that abusive environment and the facts and circumstances showed that, then yes, the same sorts of reasoning would apply. But depending on the facts, it may or may not be different.
Okay. Just in terms of, when we look at excited utterances or we look at those kinds of issues, we don't usually ask what's the context in which this, was it an excited utterance? Was it under the then existing, we have rules, we apply the facts to the rules, but it seems like you might come down differently.
Well, even with excited utterance, we look at the circumstances and surrounding of what was the situation. Was this truly an excited utterance? Was this person under duress, stress, and therefore making an excited utterance? And I would argue that it's a similar type of analysis of looking at the facts and circumstances to figure out whether the rule applies and is being met.
Any other questions?
Briefly, so if the injury matters, obviously we don't really know what the doctor or the EMT think about whether the identity mattered to their treatment, do we?
That only what was testified to through the officer.
Okay.
And it was detailed a little bit more as an offer of proof in the people's response below. But as far as testimony and record evidence goes, all we have right now, yes, is the testifying officer.
Okay.
Thank you.
Thank you, Your Honors.
Thank you, Counsel. You have time for rebuttal should you wish to take it. Okay, thank you. That case will be submitted. Now calling item number 2, docket number 365992, People v. Moran. Counsel, you may appear. Appellant, you are not endorsed for oral argument, but you may appear if anyone has questions. Certainly let me know and we can ask those questions.
Good morning, Your Honors. Marilyn Day, Assistant Prosecuting Attorney representing the people of the state of Michigan. Normally, when I'm at appellee and defense counsel is not endorsed, I'll just rest on my brief. But this case is very important to the people of the state of Michigan, Oakland County, and particularly the family members of the 2 crime victims in this particular case. This case is a true juvenile case. Miller, Alabama versus Miller applies. The question is a 40 to 75 year sentence proportionate based on the nature of the offense and the background of the offender? What defendant fails to recognize is this is not a Miller hearing case. Yes, at one point we did file a notice to seek a life without parole sentence, but we withdrew that notice. So defendant already got the benefit of our decision not to go forward. And the reason we did not go forward was because as a prosecution, we examined the case and looked to determine whether there were mitigating circumstances which would warrant something less than a life without parole sentence. So what do we have? What could the trial court have sentenced defendant to? Because defendant was sentenced under 769.25, not 25A, the minimum sentence had to be between 25 and 40 years. The maximum sentence had to be not less than 60 years. So the 40 to 75 year sentence in this case was right in line with what the statute said. It is a statutory required sentence. It should be presumptively proportionate in this case. Now, the defendant committed not one, but two cold-blooded murders. He executed two individuals in their homes.
Counsel, just let me, let's assume you were 100% correct to everything that you stated, obviously. Talk to me about there are two questions I had about this case. One is I want to know your take on sort of the de facto life sentence aspect of it. Because, yes, the max, no less than 60. So would we be here if it was 60, right? Would that be a de facto life sentence where 75, they're claiming that is? And then the second, why don't you address that? And then I've got a second question.
Well, and that's why we moved from Coles to Milbourne. We don't want to speculate how long someone's going to live in prison. We just can't do that. And in fact, I'm working on the 18, 19, 20-year-old resentencings, and more than a fifth of those individuals are over the age of 60. I had an 83-year-old defendant that just got resentenced to life without parole. So it's just too speculative to figure out if this is a de facto life sentence. And in this particular case, if we're looking at this particular case, he would have been eligible for parole at the age of 57. I'm sorry, I'm older than the 57. The victims were in their 50s. They are deceased because of defendant's actions. The fact the defendant might not get out of prison until he's 57, it's because of his decision to pull the trigger 4 separate times and execute 2 women in their home. There is no issue about a de facto life sentence in this particular case. In the 75-year, that's way too speculative. And there's case law that talks about if you're looking at the max, you don't know when the parole board's going to let that individual out. If defendant's a poster child in prison, which unfortunately he has not been, if he's a poster child, he'll get out at his original, or will be close to getting out at his minimum date. But it all depends on his behavior in prison. And that's the parole board has a job to do. That's what they're supposed to do, not the courts, not the trial courts or the appellate courts.
Right. Second question I had was, what are we to make of, if anything, with the Supreme Court, considering needs and having an oral argument on that? How should we be looking at that?
Well, Eads, they already had oral arguments, so I'm
Yep.
assuming the case is going to come out by the end of July. Eads is different than this case because Eads is a second degree murder.
Right?
Second-degree murder. This is first-degree murder. The big difference between second-degree and first-degree is we still could have gone forward with life without parole. We chose not to. Eads is just irrelevant to this case. I don't think it plays any role in this case. I'll answer any questions you might
Any
have.
questions, Judge?
No,
Campbell?
not for me.
Anything?
Thank you.
Any questions for appellant?
I don't have any.
If you would like to hear from appellant, that's up to you.
Just one, the same question that Judge Wilcox just had, if you could comment on the impact of EADS.
Yes, Your Honor. Thank you. Claire Ward for Mr. Moran. The impact of EADS, I believe, will be relevant to this court's decision in Mr. Moran's case because part of the reasoning of EADS is about the proportionality of the sentence and the de facto life element. If the court in EADS finds that 50 to 75 years for Mr. EADS is a de facto life sentence in second-degree murder, there is no reason to believe that 50 to 75 years would not also be a de facto life sentence in first-degree murder. The court's reasoning in EADS could very well encompass Mr. Moran's sentence of 40 to 75 years. And so the court's reasoning in the Court of Appeals is now before the Michigan Supreme Court, and the Michigan Supreme Court's questions at oral argument indicated they're trying to find what that minimum sentence and maximum sentence would be that would be disproportionate, that would be de facto life sentences. And it's not clear at this stage how they'll come out.
No, thank you.
Nothing further. Thank you, counsel. That case will be submitted. Next, calling item number 3, docket number 372-341, People v. Ranowski. Counsel, please approach.
Good morning, Your Honors. Brandon Brolick on behalf of the people as appellee. I know appellant was not endorsed on this. Given that, I will rest on my brief unless the court has any questions.
Any questions?
No, thank you.
No questions.
Thank you.
All right, we're all set. That
Thank
case
you.
will be submitted. Thank you. Somebody must have sat on the remote. Okay, no problem. We will recall item number 5, and we will move to item number 6, which is consolidated cases. Case number 371072.
What about 5?
Am I, four's moved,
Four's
four
moved,
got
so 5.
adjourned, yeah.
I got it.
You want to be presiding judge over there, I guess?
Just want to keep up.
So we're gonna move to, item number 6, consolidated cases, item number, docket number 371072, Lindemann v. Angstrom Tubular Solutions, and 374240, Lindemann v. Angstrom Tubular Solutions. Counsel, you may approach. State your name for the record.
May it please the court. Good morning, Jonathan Frank for the appellant. Judge Levency, welcome to the Court of Appeals. I saw in your bio that you were a participant in Campbell. I judged. If I judged you a long time ago, I hope it was fair.
There's other explanations I did not win. Not that one.
All right. I'd like to reserve 3 minutes for rebuttal.
So reserved.
All right. I want to start with the lower court's questioning of Mr. Banga. And I know all 3 of you had probably participated as lawyers in jury trials, not as a judge in jury trials. But I think it's fair to say that there's a certain amount of courtroom drama in most trials, some more than others, maybe criminal cases more so. This probably ranks on the low end of courtroom drama. That this was a case about accounting and whether a certain bonus was due based on COVID money coming in to financial statements. It's I guess for a 2-day trial, probably the jury could endure that, but that's what the case was. The reason I mention the drama element is because the court should try to imagine what it was like for the jury listening to that level of factual dispute about accounting, and then have the judge jump in when the witness was on the stand. And the significance symbolically, theatrically, in every way, legally, of a judge jumping in the middle of a examination of a witness is something that is so significant that it's risen to the level of a constitutional problem, certainly a violation. We think of the
Counsel, isn't that permissible under the rules?
to question, yes,
Okay,
there's a line.
all right, but let's say the line was crossed. Isn't it incumbent upon your client and counsel at trial to object either in the moment or at the next available opportunity? Isn't that what the court rule says?
The court rule says they may. It certainly is an option. I wasn't trial counsel. I can't speak to the reason why. There are tactical reasons that go into that decision-making.
So you would agree and concede that that didn't happen? There was no objection at the moment that the judge made the question or thereafter, or you said it was a 2-day trial. I can't recall whether that happened in the first day or the second day. but there was no,
Maybe it was 2 days of testimony, but yes,
yeah, there was no objection on the record at all to the judge's questioning. That issue never came up until it was on appeal. Is that correct?
correct.
Okay.
Right. So that's an additional issue that has to be resolved. It's not a dispositive issue, but it's an issue to be considered, which is in light of the fact that there was no objection, what's the proper remedy? And if the rule is strict, which I don't believe it is, and there's been an interesting dialogue in the Supreme Court currently, Justice Hood is taking a certain position about it, and it's a little unclear. If you read some of the things that he's written even recently, the standard of review of an unpreserved issue is dynamic. We don't know for sure. But the issue is it dispositive, yes or no, that there was no objection in the lower court record?
Does it make a difference if it's criminal versus civil?
It shouldn't make a difference. The Michigan Supreme Court first kind of announced this rule in a civil case in 1950. And so that's a case we cited in our brief. In that case, the court explained how significant it is to have the judge talking during a civil case and laid out what became the rule that got implemented in criminal cases later. But that Michigan Supreme Court case doesn't say, why is this even an issue here? We're not going to consider it. This is only a civil case. So we can assume that it's significant enough that it should apply, and we can all understand why, whether it's a civil case or a criminal case. We don't want the judges to jump in and cross-examine. One possible explanation is simply that the lower court in this case, and I know because I practice in the business courts almost all the time, regularly would have bench trials and probably would normally find it just a part of practice as a judge in a bench trial to start talking to witnesses. And in a bench trial, it's fine. But the significance, which is what I want to highlight, of the judge's comments can't be underestimated. This is only really one issue, which comes down to, do we believe or not believe this accounting? Plaintiff's counsel in the closing, and I think this is probably the most significant part of the record, in the closing, counsel says basically, even Judge Valentine commented. Now, what
help me identify for the record, what specific questions the judge asked that you feel crossed the line?
All right. The first questions were on page 153 of the May 7th transcript. And the question at the time, let's back up. It wouldn't be inappropriate for a question to be asked during a little bit of a voir dire or a portion of a trial about admissibility of a document. A judge might say, is that number 6 or number 7 or whatever? There's nothing wrong with that. These questions and answers came up as Mr. Banga was talking about the spreadsheets that he had put together. So the judge at one point on page 153, that's the background, top of 154, when there's no question that the judge is participating in, the judge starts with, sir, now your indication is that you haven't seen it. Even that, now your indication is that you haven't seen it, is somewhat adversarial. And the language is, the tone is, I watched the video. This is not just a simple question. I don't see number 6 there. Would you please point me to where the number 6 is? This is about his earlier testimony. And the judge goes on page 154, 155, 156 to ask a series of questions where she's the only one really questioning. The focus is on her in a jury trial, and the judge is asking questions in a leading manner as though we're trained to do it when we're cross-examining a witness. Here's a question, isn't that right? A question, isn't that right? A question, isn't that right? And then the aha. And so therefore that's the series of questions that she asks and leads to the conclusion that on page 156, she says, okay, that's not what you testified earlier. Correct. Now, that's not a role for a trial judge in a jury trial to say to a witness, that's not what you testified to earlier, correct? And Mr. Banga is taken aback by that because he's now being cross-examined by the judge. And then she kind of wraps it up in the substantive question, but you indicated that everybody was on accrual basis, correct? Which is the point he had made, and now she's undermining him. How could he have said that if he didn't see the records?
Well, am I correct in the record below, there was the standard jury instruction that instructing the jury that, look, you can't take judicial remarks or questions and things like of that nature. That's not evidence. Was that instruction given in this case?
Yes,
Okay.
yes.
And why does that not cure any problems you have with tone or content, as you noted?
Well, there are rules for when a curative instruction is enough. And our position is, even with the curative instruction, the magnitude of what the lower court did is beyond repair. I mean, you have to think of human nature. This occupies quite a bit of time, not only here, but then the next day on May 8th, there are even more questions on the same subject of undermining the credibility of Mr. Banga. So if we take all that happened and we have the reading of a jury instruction in a long list of jury instructions to a group of people that may or may not be tracking it or paying attention, I think the question for the court is, given all the circumstances, that's what the court has to look at, the totality of what happened. Is the curative instruction enough to have overcome what the trial court did on the 6 or 7 pages of questioning in what was otherwise a pretty short examination of Mr. Banga? So I mean, those are the issues, right? We've identified what they are. Is there a problem with the curative instruction and the fact that there was no objection? Those are not absolute bars. And our position is, given the tone and the questioning and the centrality of these questions, this court can look at the whole record and say the trial judge was out of line asking those questions, and it swayed the jury. We can't have trial court judges doing
Excuse
that.
me, did trial counsel have an opportunity to ask follow-up questions to possibly clarify, have the witness clarify or explain any discrepancies?
Yes, she did.
Anything further, Judge Cameron?
No,
Judge
not for me,
Livingston?
no.
All right, so then the other issue is the violation of the court rule and the statute regarding whether the counterclaim was frivolous. The counterclaim survived a motion for summary disposition under both C8 and C10. In the C10 motion, Judge Valentine highlighted that there were factual questions to go to trial about the unjust enrichment or breach of contract claim. We can all think, well, maybe that wasn't the greatest strategy in front of a jury to present a clawback argument where you're the employer and you paid the employee bonus, and now you're asking for the money back. Whether that's good or bad strategy is not the question. The question is it well grounded legally and factually at the time the counterclaim was filed? So the law allows a breach of contract claim. It allows an unjust enrichment claim. Michigan law has a body of law on what's called mistaken payment. You know, check shows up in your mailbox or something from somebody you didn't anticipate, you cash it. There's rules about mistaken payment. It's unjust enrichment. So that case is enough to get past a CA motion and a C10 motion. Judge Valentine may have been unhappy with what happened at trial in terms of the proof. Maybe Mr. Banga's credibility in her mind affected her review of this, but the court rule and the statute force you to look at the counterclaim when it was filed and if there's a basis for it or not a basis for it. So the first argument we have is this counterclaim didn't violate either 109 or the statute on being a frivolous claim. It's a legitimate claim. It wasn't brought to harass anybody. It's a counterclaim. The harassment starts, and I don't mean it pejoratively, but the harassment starts when the plaintiff files a lawsuit. We're not arguing that that was frivolous, but that's something that was responded to with a counterclaim. So the motivation for the counterclaim is, well, they sued us, we're suing them. And it gets past the C10 motion. So it's a legitimate, factual, and legal claim. And ultimately the jury said, sorry, you don't get that. But that doesn't make it.
Are you suggesting that anytime a counterclaim or any claim survives a C10, it's by law, it's not frivolous?
I'm saying that
Can a court still find later, based on the proofs that are established, that a claim is frivolous?
well, it would be a really high bar to jump over, Your Honor, because the test requires you to look at the counterclaim when it's filed. And that's the court rule and the statute. And at the time it's filed, we know what the evidence was. It was presented to Judge Valentine in the C-10 motion. Whether at the trial, the evidence came out weakly in support of the unjust enrichment claim, or even a witness whose credibility was
But
attacked.
can't the court make a decision at that point and say, look, it was so far-fetched at the time you filed it based on the evidence you presented to say it's frivolous? I guess as you can hear, I'm very hesitant to establish some rule that, unless you can cite me to controlling case law that says, a claim that survives C-10 can't be frivolous as a matter of law.
There's no such rule.
Okay,
it's-
but that seems to be what you're suggesting.
I'm suggesting it's a factor to consider on the record that what tipped the lower court, I would suggest, is something that happened at the trial that reflected badly on the decision to go to trial on this unjust enrichment claim in light of what had happened during discovery, the evidence that had been revealed, the documents, et cetera. That's fine. Maybe your case gets weaker.
Okay, I think we understand your point.
Okay.
Okay.
The second part of the argument has to do with the whether there were any fees incurred. And here, Judge Valentine, she gave me credit for making what she called a scholarly argument, but it is what the rule says. It is what the statute says. And this court, in an unpublished opinion, has already said that a lawyer and a client in a contingency fee case don't incur fees. It's a contingency fee case. It's not a traditional hourly arrangement. And here, the court rule and the statute allow for two things that are important. One is there has to be some type of fee incurred, which there wasn't. And both the court rule and the statute, by implication, say that you can't assess a punitive sanction. A punitive sanction, it's for reimbursement. Both 1109 and the statute allow as a penalty for the judge to move fees to reimburse.
So your read of those rules and statutes together would mean that any attorney that takes a case on a contingency fee and is faced with a frivolous claim, let's assume for the fact, cannot recover, the court can neither impose attorney fees, reasonable attorney fees, or sanctions. That seems to be what you're saying.
If at the end of this process, there is an affirmed $38,000 verdict, and there is a 40% contingency fee, which that's the agreement apparently. If there's a 40% contingency fee, Mr. Lindeman is the recipient of 60% of his recovery. He didn't get 40%. That went to his lawyer. So he's out that much money at a start. Then there are issues to be resolved, whether any of that is attributed to the counterclaim or not. Mr. Bashan was very clear because I asked him, did you have the opportunity to say to Mr. Lindeman, hey, there's a counterclaim. I'm going to have to start charging you hourly to do the work on the counterclaim. The answer was no, kind of baked it all in to my original fee agreement. So if at the end of this, that were to be the result, there would be another review. Of the 40% of $38,000, is any of it attributable to the counterclaim? Only because you're reimbursing Mr. Lindeman. The lower court did two things, I think, mistakenly. One, she put on the record she was reimbursing Mr. Bashand as though he had incurred the fee. She said that on the record. It's Mr. Bashand that incurred this problem. He ended up doing hours of work to defend a counterclaim that I found to be frivolous. But he didn't make a deal with Mr. Lindeman to get paid for those hours. To Mr. Lindeman, it was just a gift. Basically, Mr. Bashand threw in his time to defend the counterclaim. So if we assume that the only purpose of the rule is to reimburse the client, not to punish anyone, and not to make sure Mr. Lindeman gets paid for hours when he doesn't have an hourly agreement, there's no room for the court to say, and this is written down. She said, my argument doesn't resonate with her.
Okay.
But the argument we made is based on the language of the statute and the rule that say you have to incur the fees, and the whole theory being to reimburse the person who paid the fees.
You've cited in your brief, the one unpublished case
Yes,
from this
Brewer.
court that you think suggests that
Yes,
result is proper.
right.
Okay. Any other questions, Judge Cameron? Judge Liebenstein?
Quick question. One thing I'm struggling with is what was the basis for the trial court finding that the counterclaim was frivolous, or the sanction is, and I go to the prior December 2024 court order where basically the court says, for the reasons set forth in, I guess, plaintiff's motion or something to that effect. I guess every single argument that's been proffered to affirm the trial court's decision kind of has to argue all of the different factors and different reasons, from the discovery violation to not well-grounded fact, bad faith basis, to harass, et cetera, et cetera. It's hard for me to evaluate those because it's not clear, or I guess, what's your position on the clarity of why the trial court judge imposed the amount, a sanction at all, let alone the amount?
I think the lack of clarity is problematic because the argument was made, as Your Honor pointed out, that there were discovery issues and things that happened post filing of the complaint that may have colored the lower court's view of the nature of the counterclaim in the first place. The lower court didn't put on the record, for example, I'm looking at count 3 for unjust enrichment. Count 3 alleges this, and at the time this was filed, it was clear to Angstrom that those facts didn't exist, or that the law of unjust enrichment couldn't possibly cover this situation. There's no analysis of the counterclaim in its filed form. It's more a discussion of, look how this whole thing turned out.
I think true. You're all set. Thank you, counsel. You have a few minutes left for rebuttal. Counsel for Appley.
Good morning, Your Honors. Don Bashan, appearing for the plaintiff appellee. I'll first address the question of whether or not the trial court pierced the veil of judicial impartiality. I'm going to be brief. I was the trial counsel. I don't think that anyone in the courtroom conceived for one moment that Judge Valentine came close to, let alone stepping over that line. And I think anyone reviewing the record would be left with that same conclusion. I mean, it didn't happen. There was no objection made to the purportedly inappropriate questions by her at the time they were made. There was no objection made at the next break. There was no request for an additional curative instruction. There was no request made for a mistrial. There was no post-trial motion filed, nothing. No one in the courtroom believed there was any impropriety.
All those factors that you cite, does that close the door?
It does. It closes the door. Yes, it does, because plain error doctrine has not been extended to civil cases. While Mr. Frank says, well, there's been some colloquy in the Supreme Court about what may or may not happen. We're not there yet. Tolis says that plain error does not extend to civil cases. So for all of those reasons, we don't even need to get into the substance of it. But I do think I need to just very briefly, because of a few of the comments that were made. I'm not critiquing Mr. Frank. He's making his arguments. But I think it's clear when we review the record, the trial court didn't belittle counsel. She didn't belittle the witness. She didn't make any biased commentary one way or the other. She didn't engage in any prosecutorial cross-examination. For example, I raised an objection to a foundational issue. They were trying to admit an exhibit. I objected. Foundation. Defense counsel could not ask the appropriate questions to get the document admitted. The judge then asked several questions of the witness in which she said, okay, that's enough. That's a foundation. I said, oh, all right. Her objection was sustained. I'm sorry, was overruled. I objected. She helped them get the document admitted. And now they're saying that she pierced the veil of judicial impartiality. I mean, again,
Let me just clarify that point to make sure I understand. Are you saying that, and I don't have the transcript, did the questioning appellant points to as crossing the line, did that arise in the context of your objection, or is that just an example of they're two
Sure.
separate issues?
There were two lines of questions I think they're taking issue with. The one I'm talking about right now was some financial documents they were trying to introduce. And they, as I say, Your Honor, they moved the they moved to introduce those exhibits. They missed it to admit
You
those
objected on
exhibits.
foundation.
objected,
They didn't
and-
do a good job laying the foundation. She steps in and says, let me help you out. Let me lay the proper
And
foundation.
she asked the questions and the document was admitted. That
Okay.
was one line of questions. The other line of questions went to the notion of vacation time and whether certain records existed regarding a personnel file existed for my client. Mr. Banga, the witness, testified that there was a file. Then he said there wasn't a file. And then he said he thought there was a file. And then he said he wasn't sure if there was a file. And it was in response to all of those questions that the trial court just tried to figure out, was there a personnel file for him? And if there was a file, was it produced? And at the end of that, it comes out that the personnel file does exist and it was not produced. So the judge did not cross-examine anyone. I think these very limited, isolated comments do not pierce the veil of judicial impartiality. I would submit that if on this record, the court were to find that the veil of impartiality was breached or pierced, then we might as well just rescind or revoke 614. Because based on the record, any trial judge would be loath to ask any questions. Because the questions that were asked here, I think arise.
Let's say we agree with those statements. Well, talk to me a little bit where I found some problems, which is the brevity in the court's ruling on why she found the counterclaims frivolous and imposed sanctions. What do you make of that argument?
I think, Judge, that there's one issue that I think is crystal clear from this record, and this went to the counterclaim. In the counterclaim, as they allege in their pleadings, they say that Lindemann's bonus, or I'm sorry, his raise is contingent on him, quote, successfully performing certain duties. Successfully performing his duties. That's how it was pled, and that's how the case was, we went through discovery. That's how the pretrial matters worked. We dealt with all this, I'm trying to defend this counterclaim by proving that the witness successfully performed his duties. Bang is on the stand. I asked him the question, was his raise contingent on him successfully performing his duties? No, it wasn't contingent on that. So we have trial discovery, we have pretrial discovery, we have pretrial matters we work up for the case. And then the witness says, no, it wasn't contingent on that.
But let me ask you this, didn't your motion offer several, 3 or 4 alternative reasons why it was frivolous? Not just that, as you say, crystal clear.
But I think the record would also make the other ones not as crystal clear, but I apologize if I appear to be pointing. I'm not.
No, you're fine. It doesn't bother me.
So-
I've got a
so-
wife and kids at home. It happens all the time.
So the next one was, they say that he was supposed to, they allege in their counterclaim that his raise was to be temporary only while he was performing multiple duties.
So let's say, I'm sorry to interrupt you,
No,
but
no.
let's say, I don't know, you put four arguments, right? How are we to know, based on the record before us, which of those 4 or all 4
I think the assumption.
or
would be-
something else that the court based its decision on?
I think
How
that-
are we to know
I
that?
think you would know because we pointed out all of the inconsistencies in the pleadings and the testimony, and the judge said for those reasons. So if she was wrong about, if our briefs don't provide ample authority to support the award, well, then I guess that's the trial court erred. But we laid out the very specific examples of the things that were inappropriately done.
Right, I'm not saying, the issue that I see is not with how you laid your arguments out or even the merit of your arguments. I think the problem I run into, I don't mean to speak for my colleagues here, but where I run into is the requirement under TOLUS that there be a sufficiently clear articulation of the basis for the finding so that we're afforded the ability to provide meaningful appellate review, which I think is difficult under these circumstances, which is essentially no fault of yours.
No, and Your Honor, I guess what I would expect to happen quite candidly, if I'm reading the room, as it were, that
Right, reading me at least,
Okay.
probably.
perhaps, Your Honor, we'll go back and we'll rebrief this. And I would be stunned if we didn't get a finding consistent with I'm sorry, an opinion from the lower court that highlights the issues that I'm highlighting to you now. But if, it is what it is. I can't,
Understood.
her opinion states what it states, the testimony was what it was. I don't think it's going to change anything, quite honestly, because they manufactured a pleading that the proofs demonstrated were false.
Would you agree that my statement of what Tolus Oil requires us, the standard that we're to look at, would you agree with that?
Well, I'm loath to do so.
That's why I asked.
Your Honor, I would say that, I would simply just reiterate, Your Honor, that based on the arguments that we had put forth in our brief, that the court had sufficient basis to adopt those arguments and find, based on the record that was before her, that sanctions were warranted and appropriate.
Fair enough. Any further questions?
No.
Any questions?
Thank you, Your Honors.
Counsel for Appellant, you have a few minutes left for rebuttal if you'd like.
This is an odd thing, but I don't want to deprive Mr. Bashand of an opportunity to talk to if he wanted to about whether the fees were incurred, because he didn't talk about it. That's kind of the biggest issue on the second half of the case, which is they weren't incurred. And yes.
Be careful, he might bill you for this time you're arguing
No, I
on
know.
his behalf.
I know, but I think the point is that I guess the procedural question is, yes, it should be remanded on the question of the frivolity to both of your points. Yes, we can guess, and yes, maybe she'll do the same thing again, but maybe she won't, and maybe she'll say, yes, it was frivolous because 1, 2, 3, 4, and 3 and 4 are going to be things that happened in discovery, which will make your job easier, because that's not a reason to have a claim declared frivolous at the first instance when it's filed. So we do have to know more about why she's decided it to be frivolous. I want to just talk for a minute about the questioning, though, because it's inaccurate to say that the entirety of the questions was for admissibility, foundational questions. We acknowledge there's nothing wrong with the judge saying, is that a photocopy? I don't see it. There's a lot of questions the judge can ask about foundation of a document that I'm not going to argue about. She strayed into territory that was problematic, because those questions, if you look at the 6 or 7 pages, and it's not a lot of pages, but considering the shortness of the trial, it's a lot of drama. If you look at those pages, you'll see that yes, some questions were about the document, but the questioning about his integrity and his credibility are dramatically asked by the judge. She uses all the skills we've learned on how to cross-examine a witness to highlight the fact that she doesn't believe him. And that's why counsel refers back to it in his closing. So if he hadn't, we don't know what the jury would have done, but why would that comment be made to the jury by counsel unless counsel thought it was a fact that should be highlighted to the jury?
Anything else?
Nothing else. All right, thank you.
Okay, that case will be submitted. Yep, recalling, yep. Do you want to give it more time and call the other one and then call this at the end? Yeah, I understand that, yeah. Unless you tell me it's gonna be fixed in the next 10 minutes. Okay. Let me call case number 5, or item number 5, docket 369184, People v. Coleman. And
Mr. Ferroni, his case,
yeah, he's gonna appear remote. I want to call him up. Good morning, Mr. Ferroni.
Good morning, Your Honors.
Apologize, we're having some technical difficulty. I wanted to give you the option. We can see you, the judges can see you, the big TV in the courtroom, the members of the public that are here, and appellee cannot see you, but everyone can hear you. Do you have any objections to moving in that manner?
None, Your Honor.
Let me ask you, counsel for the appellee, do you have any objections to not being, as much as I'm sure you love to see and witness Mr. Ferroni, any objections to just being able to hear him? All right. Hearing no objections from either side, we will move forward with item number 5, case number, I'm probably repeating myself, but just to be careful, docket number 369184, People v. Coleman. Mr. Ferroni, please state your full appearance for the record, and then you may proceed.
Good morning, Your Honors. Michael Frone on behalf of Mr. Coleman, the appellant. I want to thank you for letting me appear via Zoom. I couldn't be there today in person. I know the court has a very busy docket. It's a somewhat complex brief. There's a lot of issues or sub-issues. It's an important appeal for Mr. Coleman. He did receive a 75-year minimum. I've stated everything I intended to in the brief, and I'm here today in the event that if the court has any questions for me.
Have any questions?
I have one question
Go ahead.
about the offense variables. I guess you don't dispute the PRV of 150, is that correct?
I think that sounds accurate. I believe we titled up, we added them up in the brief. I don't have the number in front of me. I know there's 4 variables that are at issue.
Sorry, I was asking about the prior record variables first. Let me skip to offense variables.
I don't believe we're challenging any of the prior record variables.
Okay, I'm struggling, I guess, with the concept of kind of what was the act that was the count of conviction, and this concept that of sort of like a continuous offense, like when did an offense start and when did it stop, and what is during the offense and what arises out of an offense.
Mm-hmm.
Because I see the 4 different variables, 4, 7, 8, and 11, especially 7 and 11,
Mm-hmm.
that during the offense and arising out of the sentencing offense being complicated when you add the concept of a continuous offense, that it's not, particularly here where we have essentially a sexual assault in one room and then a sexual assault in the next room. And I'm struggling with the interplay of those 3 things.
Mm-hmm. That's clearly the issue in regards to OV 11, because, and it's a matter of just reading, from my perspective, reading the record, I can't discern a necessarily distinction there in what's being described, the way it's described at trial, that there's a sufficient number of penetrations. Now, when you go back to OV 7, it's a little bit different because there's a number of things going on there. It's a very unusual situation because the victim, complainant victim, states that she was assaulted by somebody else that same night. And you have a claim that this was a human trafficking situation. And so, all right, it's not sadism. I don't think anybody's arguing that. It's not torture. It doesn't meet the definition of those 2. And so we're left with excessive brutality, something beyond the sentencing offense has to be proven, or this catch-all category, which also requires language, is a little bit different, but requires something beyond the sentencing offense. And so you've got, well, she testified that she did have to take some prescriptions that would associate with somebody who's dealing with some mental health issues, but it's not clear from the record what she's describing. Is it from the other assault, from this assault? Is it from just in general what was happening? I think if Mr. Coleman was here.
Let me try to be more precise then. With respect to 7, if I view the continuous offense being from the start of the sexual assault in one room and continuing to the next room, you could see that being torture and applying the 50 points because that whole thing happened during the offense. The problem with that is then 11 may not score, because I think the reason this trial court scored 11 is that they viewed it as sort of that the assault that happened in the second room arose out of the criminal of the sentencing offense, which was the assault in the first room. And so if I view it as one continuing offense, I think potentially the 50 points under 7 apply. If they're separate offenses, one in one room, and then the assault happens in the next room, then 11 applies potentially, because the second assault arose out of the sentencing offense.
Mhm.
That's how this whole concept of a continuous offense and how to apply those two variables in particular, I'm struggling with.
I do believe it's a stronger argument that it was two different offenses, and so therefore the points would be more appropriately scored under OV 11. I think there's a lot of problems with OV 7. So I do believe if we had that sort of conceptual distinction to make, I think it's a stronger argument that OV 11 should be scored. OV 7, our position is that it's not an excessive brutality. All sexual assaults are brutal by nature. Here we've got testimony. He threw a flip flop at her. That's a lot of points for OV 7's always a lot of points. It's an all or nothing variable, 50 points. It's a difficult variable to analyze for everyone. I know there's been some orders from the, not opinions, but orders from the Michigan Supreme Court talking about OV 7, how it's a difficult variable to score. I know I had one in this, People v. Brownfield is one of, Dakota Brownfield is one of those orders where you can find that language. So I guess I would argue that if that's how the court's analyzing it, there is a distinction there in time. There's two separate rooms were described. Moved from one room to the other. I would think the point should be under OV 11.
Is there a continuum? I mean, to me, reading the record, the move from one room to the other was fairly, concurrent. Say there wasn't like a break in time. It wasn't a different part of the house. Really, it seemed to be, kind of across the hallway. She fled and escaped from one bedroom to the next, and he,
That is what was described.
crosses the hallway.
Right. I don't believe there was a substantial passage of, well, I would say substantial. It's not the correct word. Not a prolonged passage of time. I mean, yes, that's how I read the record as well. There was an assault in one room. He indicates it's painful. This is her testimony. This is our position of what happened. It's which we have to look at. We have to look at the complainant's testimony, how she described it for purposes of the offense variables. She indicated it was painful. He gets angry, upset at that. There's maybe some words. He throws a flip flop at her. She leaves, goes across the hall, and it continues in the other room. That's how long. That's about how long it took for this to happen. I don't believe it was to try to answer the question.
I don't know, went downstairs, then came back up, or,
I didn't read the record that way. I read it to be happens in a fairly
instantaneous.
Right. But if we're thinking of it in terms of one transaction that would fit under OV 7 or two that would fit under OV 11, I think it's a stronger argument that it's two that would fit under OV 11. There is a break. She does testify that she went across the hall. If that's the court, it's considering the two issues. That would be my argument on that. And again, I just think there's other problems with the OV 7 scoring that we talked about in the brief.
Anything you want us to consider, counsel?
But no, I really, I guess I would emphasize, I think that OV1 is the primary issue from Mr. Coleman's perspective. OV2, at the time the brief was filed, there was some thought that seemed to be an area of law that was pretty active. And I think, I would somewhat agree with the prosecution. There are two different types of cases that can arise where the unanimity instruction becomes an issue. One where there's a statute that says that offense can be violated different ways and lists them out. Then there's another scenario where there is no statute. And that's, to me, is the more problematic of the two. And I would concede this case falls into the first category. There is a statute. The statute does list the different ways the offense could be violated. The law hasn't, to my knowledge, hasn't changed since the brief was filed. In conclusion, I do think the principal issue would, of course, be issue one, which I don't have anything to add to the brief. I would just emphasize that they can call an expert, and the expert can describe in general terms human trafficking, can testify what is human trafficking, what they've seen in human trafficking cases, what is indicative of human trafficking. Where they get into trouble, where the line is crossed, is where they point to that testimony, then they point to the defendant and start to draw those two connections. And in addition, you've got so I'll leave it at that, unless the court has any questions. Any additional questions?
Okay, thank you, counsel.
Thank you.
Good morning.
Morning.
Rayanne Ruddy, Assistant Prosecuting Attorney, appearing on behalf of the people. I'm going to also rely on my brief. However, I do want to address the OV7 and the OV11 interplay. OV7 and OV11 are not mutually exclusive. You can have both excessive brutality and multiple penetrations. The timing, despite the fact that they may occur close in time, doesn't make one applicable and one not applicable. For example, if you have a situation where a child is being sexually assaulted and there is a penetration anally, and then there's a penetration involving vaginally, those are two penetrations. So both of those are individually able that we can write charges against. That's 2 counts of CSE first degree. And in this case, we could have written 2 counts of first degree CSE because there were 2 penetrations. But in between the 2 penetrations, we also had a man who was throwing shoes, who knew that this victim was in horrible pain because of how he's been treating her for the last several months in this case. He knows her condition. He knows that she does not want to engage because of her condition. He doesn't care. He makes it even more brutal than he has to. He repeatedly, as she testified, and pardon me for my language, but he repeatedly thrust into her harder than necessary so that he could, with his penis, aggravate her stomach because she had said her stomach was bothering her.
Is that, counsel, is that your rebuttal to the Applebee's point about the OV7 not being scored correctly because there's no evidence of excessive brutality or savagery? That, look, by its very nature, rape is brutal and savage, but in this case, it doesn't rise to that next level, is what you said.
It absolutely does rise to that next level.
Address that for me.
Sure. So as I indicated, he was, the way he was raping her was even more cruel than just, if you will, an average penetration. This was a man who was attempting to injure her further, knowing she was already vulnerable, injure her further by thrusting into her stomach area because that's where she had complained that she was hurt. He was throwing shoes at her. He was banging her head. He was calling her filthy names. And in the context also of their relationship, she was already essentially, she was being trafficked by him. He was the one supplying her with the drugs. So he controlled her. He had more control over her than an average CSE victim might have because he would not allow her to leave him. So she was essentially enslaved to him because of the drugs.
The example you gave a moment ago was a child.
Mhm.
So let's say we have the child you described, and the child is sexually assaulted on Monday. The same child is sexually assaulted the following Friday. You choose to choose the Monday assault, not the Friday assault. Under those circumstances, could you score OV7
I don't,
at 50 points?
I don't believe so because it would depend on the circumstances. Is that child locked in a dungeon-like setting? Is the child being kept
No,
away from the
no.
parents? If it's just a teacher assaults a student on this Friday and then assaults a child on the following Friday, no, I don't think that's excessively brutal. I think that would be two clear CSE first degrees.
All right.
I don't think I could score OB7 in that situation.
Okay, and so obviously, that's an extreme example. Why is this case significantly different than the example I gave?
For the reasons that I've already stated, which was that he was, his position of power over her, she was essentially a slave to him. He intentionally was trying to further harm her, using his penis as a weapon.
All right, let me just, looking exclusively at the temporal issue, the timing, and the break in the sexual assault, the fact that there was an argument, the fact that he was upset, the fact that she left the room, the fact that she chose the room to go to. It was her room, correct?
It was her room, but I don't know if I
Let me-
would
let me
agree with
just say-
she chose the
Okay,
room,
this is
but-
not a situation where she's being sexually assaulted. She's able to escape from the bed, run to her room. He chases behind her. You'd agree that that's not this case?
Correct.
Okay,
Well, I mean, it is in some regards. She was not in, like, this was not, she was released from him and then she went to her safe space where she could lock a door and she could, comfort herself. She could take care of her injuries. She could do that. She had that, he was literally from this side of the room to the other side of the room, and he was screaming and yelling at her, and she was not safe at that point. She may have been in a different room, but she was not any more safe than she was when she was standing in his own bedroom, because if she had a door that would lock and keep him out, maybe, but she didn't. That was, I mean, it was literally, they were in the same area. They were in the same room, and that his brutality did not cease when she got up and left. He just, whatever he did, refueled or increased his anger because he had fallen. So he was even more mad at her. And he came in and he was even more brutal in her bedroom than he was previously. So his level of anger, her level of fear, all of these things that happened in between do not constitute an actual, like an average CSC. I mean,
Counsel, that's why I guess where I struggle with the OV7 scoring is, it would seem to me what the result is, if we upheld it, is based on what you're pointing to us on the record, is anytime there is a victim of, it's hard to imagine OV7 not applying in any situation that is involving, sort of trafficking and drugs and, a drug house and a house of prostitution, right?
I agree, yes.
And is that essentially what you're saying, is
I am.
anytime those circumstances arise, that's what that is?
Essentially,
Isn't
but
that-
I think Judge, oh, I'm sorry.
Well, just my last thought, and you can then expound on it, is I don't read that, right, in the language of the rule or the statute. So how do we get there being bound by the language that's there, right?
Yeah, I see exactly what you're saying. And what I was, so eloquently interrupting you with was,
You're fine.
was that it would have to be case to case by case. I mean, a lot of these human trafficking cases are the most heartbreaking. These poor people are, ripped away from their whole lives. They're brutalized daily. They're living in these horrible conditions. These guys were living in essentially a dungeon. They were not given the opportunity to use a bathroom. They had to defecate and urinate in a bucket, which they then had to dump into the same room where they were sleeping and living and having these dates with the people who they were forced to prostitute to. It is brutal and horrible in these trafficking situations. However, there could be times when it's not, I don't know that we could actually meet the level of excessive brutality, and I think in this case, Judge Matthews actually went with the or language. I'm sorry, I don't know. Let me see.
How do we, so all those factors that you talked about
Mhm.
seem to me to be tangential to the actual offense, which is where the brutality, it has to be tied to the offense. And what I've
Sure.
heard to you is sort of the force used during the offense. So really, I guess the lens we have to look at is what occurred in the four walls of those rooms, or 8 walls, I guess it would be. Is that correct? We have
Yeah.
to look at sort of in isolation what occurred in those, even though everything else you described is horrific, right?
I think, yeah, absolutely. And I think that you have to, though, take into consideration the victim's mentality, her brain at that point in time, because I don't think you can just say that this is a fresh victim, somebody that was snatched off of the street who is terrified, but who doesn't have that background of being repeatedly beaten by this man and repeatedly prostituted out, and he's forcing them to stay because he gives them the drugs. So those are things, I agree that that's not specifically within this offense. However, her mind is.
So is there a case or case law you can point us to that says when evaluating the portion that says conduct designed to substantially increase the fear and anxiety of a victim, what you're suggesting is to evaluate that, we have to look at the unique circumstances of the victim?
Yeah, yeah, I think that that's under a
And
totality.
and is there a case law that says when you evaluate that, you're to look at the, not sort of an objective, reasonable person, but rather the unique circumstances of this victim, this crime, which would be all the surrounding parts? That's what that's what
guess
you can hear. That's what I'm struggling
Sure,
with,
sure,
right?
absolutely. And I don't know that I can actually point you to that particular case law, but I kind of think that we have to consider our victims as human beings, and they're not just a interchangeable thing that goes from place to place. If we don't consider the victim's particular state of mind or their particular station in life at that point, I think we're doing a disservice to that victim, because somebody who's been through what these women have, and particularly the victim whose first initial is A, was she doesn't have the same life experiences that I've had, and I've been incredibly fortunate. She has not. And I think that you can't disregard where she was in her world and how this happened and how she faced this, because the brutality was allowed. He was doing these things excessively brutal because of how she was indebted to him, and that she was his slave, and that she was supposed to be there when he wanted to have sex. So I don't think we can separate the two, because this is an especially vulnerable victim. And so
The measure of brutality for OV7, is it the brutality and severity of the rape, or is it the brutality and severity of the trafficking? Because those are two separate.
correct. I think it's the whole picture. I think we don't look at these OVs in isolation of just, I mean, we do in the sense that we call it, we're looking at the 4 corners or the 8 corners, but I think we don't look at them in a vacuum. I think we have to look at them as it applies to this particular case. And I don't think that we can just say, you know, there was another guy that I had whose case I dealt with before, who was he decided to get overly aggressive with his girlfriend, and then he yelled at her and threw a shoe at her, and then she went to another room, but he followed her. I don't think that's going to be the excessive brutality that we have here, because in this case, she has a predisposed fear of him. She already knows that she is obligated to allow him to abuse her, and she essentially in the past has agreed, and if she's ever resisted, she knows it's going to be worse. So she in the past has sort of allowed it to happen, and here she's clearly resisting it, and she doesn't want to participate. She informs him that she's not feeling well, and yet he, rather than saying, okay, well, you got 2 hours, he rapes her even more brutally than was necessary. This wasn't his, I think he was actually using using his brutality and his excessive anger as possibly as a sexual gratification to try to make her feel less, to make him feel superior. Because I think that was his goal in a lot of this, was that he was a number one, everybody else was dirt, and everybody else had to submit to him. So with regard to your question about OV7 always being present in trafficking cases, I think a lot of times they might be, but I think we still have to look case per case per case, because I don't know that we can actually make a call. And I think that's what Judge Matthews did in this case, is that she was looking at the specifics that were going on while this rape was happening, in addition to the fact that it didn't stop. It kept going.
Any other points you want us to pay attention to?
No, I don't think so, unless you have any further questions for me. No?
Okay, thank you, counsel.
Thank
Mr.
you.
Peroni?
And welcome, Judge.
Your Honor, I believe, if I'm not mistaken, OV7 is a McGraw variable. We have to sentence it or look at OV7 based on the sentencing offense. We can't take the human trafficking testimony and bring it in when we're sentencing Mr. Coleman on the CSC first count, and the other way around. I think we have to make that distinction. It's a case, it's a trial that has some ugly testimony. It lends itself to, but I hear a lot of speculation from the prosecution about what Mr. Coleman intended. My reading of the record, I don't know that he intended to cause pain. I got to push back somewhat on what I've just heard. My reading of the record is that he became upset because the complainant indicated that she was in pain. And I'm not defending any of this, but that would, and that's what he gets upset about. That would indicate to me he wasn't trying to be a sadist. He didn't want to hear her indicate she was in pain. I would think a sadist would want her to be in pain. So I just read the record. I'm not, it's not good, but I read the record fundamentally different from the prosecution. And in the end, we have to look at the statutory language. Sadism has a technical meaning. I don't think the trial judge concluded it was sadism or torture. So that leads, is it excessive brutality? I read that to mean brutality is not enough. That's inherent in the offense. It has to be excessive to the offense. He's trying to commit, he's convicted of it. We have to respect the jury verdict when we're analyzing the guidelines. He's convicted of it. He's trying to commit the offense. I don't know toward that end that throwing a flip-flop, pursuing her to the other room, any of these things that we've heard would satisfy that term, excessive brutality. Then the fourth category, similarly egregious to excessive brutality, designed, intended. That brings in a subjective element for Mr. Coleman. We've heard a lot about the subjective element of the victim, but designed to substantially increase the fear and anxiety the victim suffered during the offense. I'm not defending this type of behavior, but I would submit that there's not an excessive brutality or similarly egregious conduct designed to substantially increase the fear and anxiety. It looks like a scenario in which, according to the prosecution's argument, OV7 would be scored 50 points in every single human trafficking case and in every single CSC first case. Could be scored every time. That's all I have, unless the court has any questions.
Okay, thank you, counsel. Thank you for your patience with our IT difficulties on this end, both of you. That case will be submitted. Calling our final case for the 10 o'clock portion of our case call today, case item number 7, case number consolidated cases, docket number 370690 and docket number 370766. Counsel for the appellee is endorsed for our argument. Counsel for the appellant is not endorsed, but we may have some questions. Counsel, you may state your appearance for the record.
Thank you, Your Honor. Your Honors, Charles Penzine on behalf of the Teeter appellees. And for today's argument, I would suggest we split the time between the other appellee group as well.
Okay.
Your Honors, given the fact that appellant is not endorsed for oral argument, I tend to rely on my briefs as others do. I know Your Honors do a fantastic job and know the case very well. I would just note and emphasize one thing. In terms of the underlying trial court, there were no abuses of discretion in this case, judges. Given what has happened during the trial court, given the appellant's obsession that there was a conspiracy and all the talk of that and what's occurred during that trial, post-trial, continuing into this case, so on and so forth. It's our position that there certainly was no abuse of discretion. In fact, what we were concerned about when we filed our initial motions came to pass and continues to pass as we live through this process today even. So other than that, if you have any questions for me, I'll turn it over to my
Any questions, Judge
brother
Cameron?
counsel.
Counsel, you may approach and put your appearance on the record,
Thank you, Your Honors.
and you have plenty of time.
Good morning, Your Honors, and welcome Judge Alan Francis for the St. Clair County Drain Commissioner, pardon me. I will also rely primarily on my brief. My overarching position in this case, the Drain Commissioner was dismissed, or the attempted claims against the Drain Commissioner were dismissed very early on. The Drain Commissioner has no involvement in the underlying claim that was filed by Mr. Teeter. This is a garden box, literally a garden box case.
Garden box.
Thank you. Garden box didn't seem like the right term, but frankly, I used it in my brief, so that's what I was going with today.
Yeah.
So we are not, the Drain Commissioner is not a necessary party, an essential party, any of those matters to the underlying dispute. I'm here to answer questions if there is any, maybe on the disqualification issue, which, as I noted, I didn't get served with that brief because we were out, but I think I covered it in the appeal brief.
Questions? Any questions, Judge Livingston? No questions. Appellant is not endorsed for oral argument. Any questions for appellant?
I don't have
Any questions? No questions. That case will be submitted. That concludes our 10 a.m. Case call. We are moving to the 11 a.m. We're going to take a brief break and return as quickly as possible to move to the 11 a.m. call. So we will try not to keep you waiting very long. Thank you for your patience while we took a quick break. Hopefully you all found it as beneficial as we did. Moving to the 11 o'clock case call. I believe everyone was sitting in the courtroom earlier when I went over the rules, but the same rules apply earlier. I'll just reiterate again in a reminder that if there are any cases involving children or sexual assault victims or anything like that, please use initials or some other non-identifying identifier, if there is such a thing, to refer to any of the victims. With that said, we will move to the first docket number 8, case number 370496, the Wilkie Revocable Trust versus Stano. Good afternoon. Good afternoon. Are we afternoon? I think we're still, oh, just barely, just barely. Appellant, you may approach, state your appearance for the record.
Good afternoon, Your Honor. Mark Chiazza on behalf of the appellant defendant Peter Stano. Your Honor, we did have between Mr. Weatherly and I, we had a question, a housekeeping matter that I'll let him address.
Okay.
Yes, and we have the direct appeal, we have the cross appeal. Would you like Mr. Chesa to argue his direct appeal and then address the defense of the cross appeal? So we can stay at the podium, however the court would like to proceed.
Yeah, why don't you, we'll kind of play it by ear a little bit, but why don't you address everything and then we'll go to you and then you'll get rebuttal. Does that work for both of you?
Yeah, that's fine, Judge. We just wanted to make sure we had a understanding of.
Yeah,
course.
as long as you're all on the same page, I think, does that work for
Yeah,
you, Judge
absolutely.
Cameron, Judge
Yep.
Legacy? They're all set. I think we're all on the same page. You may proceed.
Thank you. Your Honor, again, in the brief, the defendant appellant raises 5 issues in his brief. I'm going to focus on the one that I believe is strongest and most compelling, and that, of course, is dealing with the statute of limitations. I think everyone in this case, including the trial court, agrees that all the loan documents are contracts, whether it was the mortgage document, the mortgage note, the loan agreement, and of course, the personal guarantee signed by the defendant appellant. I also believe that everybody agrees that the statute of limitations for contracts is 6 years as conveyed in MCL 600.5807. With regards to the specific loan agreement signed by the company, Your Honor, it clearly states that the loan is due and payable on 3 events. 1 is the lender's demand. 2 is the date the project is completed, or 3, the occurrence of a default. There is no question there was never a lender's demand. In fact, I think the testimony, or there might have been a stipulation that the lender's demand was upon filing the complaint. The complaint was filed on December 11th, 2020. Date the project was completed, again, everybody concedes this project really never even got started, and so there was no completion date. So then with regards to the third provision in the loan agreement, when the promissory note is due and payable, is the occurrence of a default. The loan agreement, again, is very specific and states the failure to diligently pursue construction or abandon such construction is a default. And again, I don't have to cite case law to this court, but like the Sayburn case, all indicate breach of contract, the statute of limitations begins on the date the breach occurred. In this case, again, there was 2 clear breaches. The first one occurred on October 17, 2012. The company URI had 3 members. The members met on October 17th, 2012 and said, this isn't working. We got to kill the construction. The second breach occurred on.
The instruction, or was that Mr. Wilkie would no longer loan money?
He would no longer loan money was the testimony, Your Honor. But again, it was clear that it was killed at that day because they didn't have the money to move forward, obviously.
Could they have made a capital call under the LC?
There could have been. There were many capital calls made, but yes, a capital call.
So the construction could have proceeded had a capital call been made.
Yes, but you have the principal member saying, hey, I'm done. I don't want the project to move forward.
But under the operating agreement, the principal member would have been violating the operating agreement by refusing a capital call.
That's true, Your Honor.
And then Mr. Stano could have sued him for breach of the operating agreement.
Correct.
But so is there an obligation under the loan agreement for Mr. Wilkie to have loaned more money?
No.
Okay.
No.
Thank you.
Again, the second breach, of course, again, if the court isn't convinced with regards to that breach.
I just have one question. I'm only one of 3, so.
Right.
And those are just some questions I had.
Fair enough, Your Honor. There was a PDD, Plan Development District Agreement signed between the company and City of Canton. That document was signed on May 19th, 2008. It was a recorded document. That document specifically states this
agreement to construct, you must be complete with your construction within 6 years. Again, that agreement was May 19th, 2008, meaning the construction had to be completed by May 19th, 2014. And again, whether we use 2012 or 2014, both of them fail the statute of limitations because the complaint was not filed until December 11th, 2020. Now, with regards to one of the big claims made at the trial court, before the trial court, I think in the appellee's brief, is that the defendant, the appellant, waived his right to, raise the statute of limitations issue. There was no waiver, Your Honors. In fact, that's not even what the trial court determined. In the judgment signed by Judge Ewell, under conclusions of law, he states, this statute of limitations is not applicable to the contracts in this case. Again, he's not saying it was waived. This is a determination by the trial court. He's not saying, hey, the defense waived that statute of limitations argument. He's saying it just doesn't apply. Again, we have no understanding of why he reached that conclusion, but obviously it's the appellant's position that was an error. That's again, the judge had the information to rule on the statute of limitations. It's clearly a contract case, and again, it's clearly a 6-year statute of limitations. Again, in my brief, I addressed the fact that, again, statute of limitations was raised in the affirmative defenses. It was raised in the interrogatory responses. It was raised at Mr. Stano's deposition. So for the plaintiff and the appellee to say we were surprised by this at trial is just simply wrong. I also want to point out that the key document in this case was Plaintiff's Exhibit 37. And again, for all of us who have tried cases, you get surprises at trial, whether it be witnesses testifies different, whether a witness, makes an admission. In this case, on the eve of trial, actually, I think it was on the first day of trial, because I was, again, trial counsel. The plaintiff handed me Plaintiff's Exhibit 37, which is a record of the loans made. Now, normally, as an attorney, if you get a document the day of trial, you're going to object to it. Hey, I didn't have a chance to review it or whatever. Again, we're not supposed to be surprised by documents. The defendant admitted to having this document entered because it supported, in fact, helped his case. This was testified by both Mr. Wilkie and the CPA, clearly indicating that the last loan made was in 2012. I believe it was January 6th of 2012. So this document, again, was black and white as to when the last loan was made on this note. It was admitted into evidence, clearly defining that there was no additional loans by Mr. Wilkie. So again, we have another red line date of January 6, 2012.
You suggesting that's the date of accrual?
Well, again,
but
because again, with, if I may, with regards to loans, again, if there's additional loans, then.
But that's why you're saying.
Correct.
Thank you.
Judge. Correct. The last point I need to make is the fact that, the plaintiff appellee keeps asserting that the loan to URI, which was the company, is irrelevant. We're just suing on the personal guarantee. But again, that ignores the fact that the personal guarantee is, derivative of the original loan. If the original loan And there's substantial case law that says if the original loan is eliminated, wiped out, paid, the personal guarantee goes away. And then in fact, in this very case, after the judgment, the company owned some land in Canton, the land that was going to develop. It was sold, and pursuant to an order of the court, Mr. Stano is getting credit, which he should, for all the payments received. It's on a land contract received by the company as a result of the sale. So for when the plaintiff and appellee says, hey, we're only suing on the personal guarantee, I think that ignores the overall picture that, again, there is the loan, that the underlying loan was between the plaintiff, Mr. Wilkie, and the company. And if that gets wiped out, then again, there's no personal guarantee. That also goes, there's case law that says, hey, the guarantor can use any defenses available to Uptown Ridge. And essentially that's the argument we're making with regards to the statute of limitations. Again, the other issue that I was going to wait and address the court was with regards to the tax losses. Again, that is the basis of the plaintiff appellee's cross appeal. And the main point I would make with regards to the tax losses is, again, there's claims that there was no evidence of it entered into at trial. And that's simply wrong. All of the business tax returns for the company from 2013 through 2019 were entered into evidence. I think they were probably stipulated to, but it doesn't change the fact they were admitted into evidence. These tax returns show how much loss the company had on a yearly basis. And again, pursuant to the agreement of the parties, it was entered into evidence that the two other members agreed that Mr. Wilkie could in fact take the tax loss because it would be his most beneficial to him.
Well, that gets to the point, right? Like a tax loss is more or less valuable to maybe you versus me, right? Tax loss is one thing, but the value of the tax loss depends on the person taking the loss, right?
Not exactly. Again, that was a question that I asked them, the CPA, Mr.
But you just said you agree that Mr. Wilkie would take the tax loss because it was most beneficial to him. And now you're saying that the amount of the tax loss doesn't.
No, maybe I misunderstood your question. I thought you were questioning is how do you determine the amount of the tax loss is the way I interpreted your question.
The value to you or me of a tax loss is different.
Correct.
So why should your client get half of what ended up being Mr. Wilkie's benefit of the tax loss?
Because of the fact that, again, every plaintiff or victim, however you want to title it, has to mitigate their damage. Any plaintiff in a tort action has to mitigate their damage. Second, it goes to the underlying balance owed by the company. Again, I just indicated, the land was sold, the land contract, and that was, an example used during Mr. Wilkie's deposition, also at trial.
But counsel, if you just stated the principle that victim in tort has to mitigate damages, aren't we dealing with breach of contract here?
We are, Your Honor, but
Contract, is there any obligation to mitigate damages?
absolutely. There's
What provision is that?
there's case law that establishes you have to mitigate your damages. And in any case, whether it be tort or a breach of contract is my belief and opinion.
What I'm struggling too is I guess you can see that there was an agreement among the three parties that Mr. Wilkie would get the benefit of the tax loss. And then he did so for the period of about 2005 to 2011, give or take. If the building ended up being built, would Mr. Wilkie's profits have been lowered or share of profits because he had gotten that tax benefit?
Again, that's a hypothetical that we didn't encounter, but I don't believe so. Again, they had an agreement. It's essentially a resolution passed amongst the three business members. So again, I don't believe that, but again, even with that answer or that understanding, I don't think it changes the defendant or appellant's argument.
I guess my question about why should your client get the benefit of what half of what was Mr. Wilkie's tax benefit versus perhaps 1/3 of the taxable loss for your client to take, and that will have whatever value to him that he made.
That is a great question that I was going to address to the court because, again, I anticipated that. First off, at that point that these losses, were being taken, for the most part, Mr. Wilkie had already bought out or assumed Mr. Dodge's ownership in the company. So again, at the later time, the two owners were essentially Mr. Stano, my client, and Mr. Wilkie. And so it's our contention that, again, that's what the court did, Your Honor. The court said, and in the ruling I just waived at the court, it says, hey, I'm only giving credit for half to Stano because I'm giving the other half to Dodge. But that shouldn't have happened because of the fact that Dodge was no longer even an owner.
Why should your client get the benefit of 1/2 of Mr. Wilkie's rather than 1/3 of the taxable loss? And then the value, your client could take that taxable loss and it might be worth more than it was to Mr. Wilkie. It might be worth less.
Correct. But again, I'm looking at
reason I asked the question is, doesn't that, the fact that the answer is you're not sure, doesn't that reveal the trial court's error in giving your client the benefit of 1/2 when he only had a 1/3 interest in the tax loss?
I understand that, but again, when I look at the bigger picture, and that's what I think Judge Ewell or the trial court did was, again, you have an individual that's undisputed. Mr. Wilkie loaned the company $800 and some $1,000, was charging interest, etc. Again, anything that he receives should come off that sum. I think that's the law of Michigan. And again, I keep referring to the example with the land contract. If he was owed $800,000 and the property sold for $800,000, we wouldn't even be here because again, he would have recouped all his money. And in my opinion, again, that's his duty to mitigate his damages. And again, by him claiming the loss, he's getting essentially some of his money back.
Counsel, I want to just keep you on track in terms of your time. If you want to save some time for rebuttal, are there other points that you want us to address before you allow brother counsel up?
No, Your Honor. And again, I meant to reserve 5 minutes for rebuttal.
I got you. Don't worry about it.
Again, there were other issues raised, obviously, in the appellant's brief. But again, the statute of limitations and certainly the tax loss are the most compelling or the biggest issue ones.
Okay, you have time for rebuttal.
Sorry if I took up too much of your time with too many questions.
Good afternoon, Steve Etherly on behalf of the Mark L. Wilkie Revocable Trust. Your Honors, this is not the first time this specific guarantee has been before the court. At the interlocutory stage, this court peremptorily reversed the trial court, finding the guarantee unambiguously covers both the initial $200K loan as well as any and all existing and future indebtedness and liabilities of every nature and kind, now or hereafter owing from debtor to creditor, however and whenever created. I'm going to start with obviously the direct appeal and the statute of limitations. The trial court correctly rejected Stano's statute of limitations affirmative defense. The court should have ruled that the statute of limitations defense was waived. There's no dispute that Stano has the burden to prove his affirmative defense of statute of limitations. Stano admittedly raised the statute of limitations in his pleading, but the parties engaged in discovery. They had facilitation twice. They had cross motions for summary disposition. There was an interlocutory appeal, which again was before this court. Stano never argued nor proved the statute of limitations. and Stano admits he never asserted the statute of limitations defense in the final pretrial order. Even just a cursory review of the trial court transcripts, the statute of limitation defense comes out of left field. And brother counsel points to a plaintiff's exhibit 37, I thought it was 17, that showed the loans that needed to be calculated. Stano's argument that he didn't know the last loan was made in January of 2012 is incredible, given that Stano is the managing member of the LLC. He's the keeper of the records. He's the one that signs off on all tax returns under penalty of perjury. So this argument that he just learned about when that last loan was made, that is just incredible. Moving to the merits of the statute of limitations, the clock started when Wilkie accelerated the debt and filed the lawsuit to enforce the guarantee. Admittedly, Your Honor, this case was not cited in the joint brief, but I'd like to point it out. It is the Diversified Financial Systems v. Chenals 203 Mich. App 589, and that's a 1994 case. It's instructive as to when the statute of limitations is triggered in a guarantee. In that case, it held that the bank filing suit to accelerate a promissory note and enforce a guarantee, that is what triggered the statute of limitations. The joint brief does cite to, I believe it's Mazur v. Young, which is a Sixth Circuit opinion applying Michigan law, which cites back to Diversified. And that case also says that a guarantee is breached and statute of limitations start to run only when a demand is made to enforce the terms of the guarantee. That is what happened when Wilkie filed his lawsuit. Going to brother counsel's two breaches that he points to. The first one being the alleged October 17, 2012 membership meeting. Your Honor, you're exactly right that the testimony showed that was the time where Mr. Wilkie, he was no longer to keep making discretionary loans to the membership. At that time, Stano, as the managing member, could have done a number of things. He could have made a capital call. He could have sought outside financing. He could have, found the money himself, but he didn't do that. The second breach that brother counsel mentions is the Uptown Planned Development District. Your Honors, that's a red herring. Whether Uptown was in default of a loan by not constructing in accordance with the I'm calling the PDD schedule has no impact on Stano's liability under the guarantee. Stano's reliance on the PDD wrongly assumes that URI Uptown had the financing to then develop the property. That PDD was only Canton Township basically giving the green light. Yes, you can go forward and pursue this. And I believe brother counsel in his brief mentions that they didn't complete construction by the time frame in that PDD. Well, that really goes to the managing member could have asked for an extension from Canton Township, could have done a number of things, and that is Mr. Stano. Your Honor, unless you have any questions on the direct appeal, I was going to move to the cross appeal.
Go ahead.
Thank you. So the cross appeal, yes, it only addresses the trial court's reduction of Stano's liability under the guarantee based on the URI tax losses taken by Mr. Wilkie. Again, this is not the first time that this case is before this court where the trial court judge read in limitations into the guarantee agreement. So again, this court at the interlocutory stage stated that, or ruled that the guarantee has clear and unambiguous language. There's nothing within the four corners of the guarantee that permits reducing Stano's proportional 1/3 liability of Uptown's indebtedness. The tax losses have no effect on the underlying loan balance owed by Uptown to Wilkie, nor does Stano's has it have any impact on Stano's proportional liability. The only expert testimony in this case came from Mr. Burke, and he testified that the allocation of losses arising from the operations of Uptown would have no connection or effect upon the indebtedness of Uptown to Wilkie and guaranteed by Stano. Mr. Burke testified that the losses are not allocated based upon the loan shown on the books. In short, the loan balance remained the same, and Stano must pay his proportion of Uptown's debt. And I think for this issue, Your Honors, it's important to visualize Wilkie as wearing his lender hat and Wilkie wearing his member hat. The losses that were allocated to Mr. Wilkie was while he's wearing his member hat. It's a decision made by the members, and it's an agreement made by the members. And Mr. Stano admits in his brief on page 18, per an agreement of all three members, they agreed to permit Wilkie to claim 100% of the losses, as he was the only member which would financially benefit from this loss. There was no evidence at trial that the members changed that agreement, that they made a different decision. And the testimony from Mr. Burke, Uptown's accountant and the only expert, was that the allocation of the losses were carried over until 2019 when was the last tax return they filed. Your Honor, and the points as to the calculation of the amount of the losses, our argument is that the tax losses are relevant and shouldn't be considered. But if the court believes that the losses are relevant, there at least needs to be a remand as to the amount at issue. You can't just look at the K1s and just add it up and say, oh, this is a benefit that was given to Mr. Wilkie. Passive losses need to come off of passive income. There was no test that Mr. Wilkie's personal tax returns were never entered into evidence. There was no testimony at the trial. There was no deposition testimony about Mr. Wilkie's personal tax returns. Again, because it would have been objected to because it's irrelevant from the enforcement of the guarantee. But if the court decides that the tax losses amount is relevant, then there at least should go to remand as to what the financial benefit would be. The trial court also, in its tax loss issue, wrongly credited Mr. Dodge with the other half of the purported tax credit amount. It's confusing. Why would Dodge, a then non-member of Uptown, be entitled to half of the losses taken by Mr. Wilkie, especially when all the evidence at trial proved that the members unanimously agreed that Wilkie would claim 100% of the losses. And unless the court has any questions, I will take a seat.
Any questions, Judge Lindsay?
Thank you.
You may approach. You have a few minutes for rebuttal.
So again, the opposing counsel makes a big point that Wilkie was both a member and a lender. In fact, Mr. Wilkie also signed the exact same personal guarantee that Mr. Stano is being sued upon. Mr. Dodge did as well, but he was released. But obviously that raises some issues there alone, because again, was Mr. Wilkie going to sue himself as defaulting on the loan? I mean, he signed a personal guarantee, so in essence, he could be both the plaintiff and defendant on the same case. But with regards to the tax losses that opposing counsel just brought, the tax code is very clear. He is right, it depends upon your income, but again, Mr. Burke testified that Mr. Wilkie has sufficient income to utilize 100% of those tax losses. Furthermore, the tax code says, hey, you're only allowed a certain percentage. So it can be ascertained just by simple math, looking at the tax returns, how much the total losses were. He's entitled to take, I don't know what the percentage is, I'm not a CPA, 10% of those losses each year. And so it can be ascertained as to the specific tax benefit that Mr. Wilkie was receiving. Again, I take issue when opposing counsel says the PDT is irrelevant. It's not irrelevant, okay? He is 100% correct. It was a document signed between the company and the city. But it details the fact that they had to complete the construction within 6 years. And the point of the PBD argument is, again, one of the terms of default was abandoning construction. Clearly, there was an abandonment of construction, and the PDD is evidence of that. My final point would be that, again, in the brief, it was addressed in greater detail than an oral argument, but with regards to the final pretrial order, again, the defendant concedes there's no reference to the statute of limitations in the final pretrial order. However, there's nothing in the final pretrial order which prevented, in this case, the defendant from raising an issue of law. Granted, the judge's instructions, his protocols indicate, hey, if you don't raise an issue or of law in the final pretrial order, it may not be allowed. Okay. It's conceded that what is language in the judge's protocols, but the protocols are just instructions. Okay. If that language that said, if this is not raised in the final pretrial order is barred, I wouldn't be making this argument. But there is nothing in the final pretrial order which bars introduction of the statute of limitations issue. For all the reasons stated, again, we think that or believe that the decision of the trial court should be reversed and a dismissal with prejudice be entered. Thank you.
Thank you, counsel. That case will be submitted. Moving to item number 9, which is consolidated cases, docket number 369890, docket number 372024, Gonti v. Benderoff. Counsel, you may approach and state your appearances for the record.
Good afternoon. Beth Whitman appearing on behalf of the defendant. So in this case, Mr. Benderoff he seeks to have the payment of any monies on the promissory notes from individuals who also were named jointly on those promissory notes to offset the amount of the consent judgment that was entered against him in this case. So this case, and I know that the panel's well aware of this, Mr. Benderoff and William Gonti, who is the plaintiff's brother, they were jointly and severally liable for repayment of monies to Sheldon Gonti. Mr. Gross also was jointly liable for a portion of the loan amount, a $200,000 loan amount. In this case, though, Sheldon Gonti only sued Mr. Benderoff. He did not sue his brother. He did not include Mr. Gross in this case at all either. But William and Mr. Gross are also liable for the same amount of the damages that Mr. Benderoff was responsible for under these promissory notes. So this case essentially involves the Markley decision where you can only have one injury and one recovery. That's essentially it. So application of this one injury, one recovery rule here is necessary because otherwise it's going to involve essentially a windfall to Sheldon Gante if he is allowed to then recover amounts under these promissory notes more than what he was actually entitled to. The $2.65 million consent judgment has to be reduced by any amounts that were paid on these promissory notes. I had included in my brief basically an example of how this would essentially work out. That because it's the plaintiff's argument that Mr. Sheldon Gante had compromised the amount that he was entitled to under these promissory notes, that he took 2.65 million against Mr. Bendroff, even though he was entitled to much, much more. There was an evidentiary hearing below. It's not clear how much more he thinks he's entitled to, but it's certainly more than the $2.65 million consent judgment that he has against Mr. Bendroff. That's his position, at least. So his remedy then would be to obtain any excess amount that is owed under those promissory notes against any of the other jointly responsible individuals under those promissory notes. But anything that he obtains in addition to that excess amount should then operate to reduce the amount of consent judgment. And the example that I used, assume that he compromised his amount that he's due under the promissory notes by $1 million. So the total amount that he believes he's due is $3.65 million, which is $1 million more than what the consent judgment is. So if the evidence demonstrates that one of the other joint individuals, the joint debtors, paid hypothetically $2.1 million, then that first $1 million would go directly to him. I mean, he gets the entire amount, but the first $1 million is free and clear because that covers the excess amount that he is owed under the promissory notes. But that additional $1.1 million that he also obtains should then reduce the amount that Mr. Bendroff is required to pay under that consent judgment. Because otherwise what would happen is that he would get $2.1 million from a joint debtor, and he would get $2.65 million from Mr. Bendroff. So he would then get $4.75 million recovery on a total $3.65 million debt. So that's why this is important. This is, and he may be entitled to more, but that entitlement to more, or the fact that he may have compromised the amount that he's entitled to, still shouldn't affect this offset that Mr. Bendroff should obtain. And there was an entire evidentiary hearing that occurred over a 2-day period in front of the trial court judge. The evidence established that the monies that Mr. Sheldon Gante received were in repayment of the loan under the promissory note. And the reason why we know that is because his accountant testified, and his accountant said none of these amounts were actually designated as income. So the only way that could not be designated as income is if it was a repayment of the basis of the loan. If it was an amount that was due for a malpractice action, which he had against Mr. Gross, that was part of the claim that he had against Mr. Gross, that still constitutes as income. So that would have to be recorded on the tax or income tax. But that wasn't done.
What you're getting here, I guess, is you said payment on the debt. And then, so does it matter? I mean, you identify a few different categories of potential payments. And I mean, it seems to me it matters where the obligation arises for each of those payments. Life insurance proceeds.
Correct.
Malpractice, there's criminal restitution, there's payments from the brother, and then there's payments from the family. Each of those can be treated differently, right?
I think so, but the amounts, it's certainly for the Shoreline policy, those are designated specifically in the promissory notes. That he was entitled to that. So that's under the promissory note. The gross admirable payment. That was the malpractice payment that was done. That had to do with, again, Mr. Gross's, I think, the way he set this up.
Should the consent judgment have provided?
Okay, so that's a good question. There's the recent case that this court had that I had to write it down because it's a lot of letters, IGCFCO case, which the plaintiff's counsel cites to in his brief. In that case, there was a consent judgment. There was the proceeds of the sale that then reduced the amount of the judgment that was due and owing. And the defendant in that case then wanted to reduce the judgment by further amounts, which were the rents that were, I think, paid for this building. But the trial court certainly held that it wasn't clear that those rents were actually part of the deficiency judgment. Plus, there was no evidence of those rents having ever been paid. And this court held that there was no entitlement of the defendants to the offset in that case. But here, I think it's distinguishable in this case because there's no dispute here that the consent judgment involved the joint liability of these three individuals. Yeah, and it certainly involved the contents of these promissory notes. It's, I think, unlike the IGCFCO case where it was unclear that those rents were actually part of the deficiency judgment. Here we know exactly that those promissory notes were monies that were due jointly by William, Mr. Bendroff, and Mr. Gross. With respect to I just wanted to address the Shoreline policy issue really quickly. Because of the trial court's ruling that the Shoreline policy was not going to apply, there was no discussion or testimony or evidence that came in as to the amounts that were due and that were actually paid under that amount. But there was at least testimony from the CPA, and I believe from Mr. Sheldon Gante as well, that there was no large payment or anything that was determined to be income. So I think the takeaway from that is that this would also fall within the repayment of the loan, and it was therefore not indicated as income. But because there's still questions involved as to the amounts that were due and owing, particularly with respect to William, William had testified, even though the judge had made a ruling that William the amounts that he paid on these promissory notes wasn't going to be reduced. He did testify. He said he made approximately 20 payments, maybe around $100,000 on these loans. And he also indicated that he had given Sheldon an interest in an investment firm with an estimated value of about $2 million. So it's our position that this case has to be returned back to the trial court. There has to be an additional evidentiary hearing to determine the amounts that Mr. Sheldon Gante received, what he was paid that would then offset the amount of the consent judgment.
Anything else, Judge Cameron? Judge Levinson? No further questions. Thank you.
Thank you. I'll reserve the rest of my time for rebuttal. Thank you.
Yes, you have.
Good afternoon. May it please the court, Gary August appearing on behalf of the plaintiff appellee Sheldon Gante. Your Honors, the most significant fact in this case is that Dr. Gante and the appellant entered into a single sentence consent judgment on June 27th, 2017, which reads in its entirety, "It is hereby ordered that judgment is issued in favor of Sheldon Gante and against Brian Benderoff in the amount of $2,650,000, period." That's it. It is under the structure of the parties' consent judgment that this court must adjudicate the rights of the parties with respect to each other. So what is the consent judgment? The jurisprudential characteristics of a consent judgment relevant to this appeal are as follows. Number one, a consent judgment is a voluntary contract between two parties to a lawsuit. It is not an adjudication by the court of any contested issue. The consent judgment gets interpreted by the court like any other contract. Courts cannot remake the terms of the party's consent judgment, just as courts cannot remake the terms of any contract between two parties. A consent judgment also replaces all the underlying agreements, notes, contracts that pre-existed between the parties. Under Michigan Supreme Court precedent in Guardian Trust Company versus Rude, 308 Mich 168, all those underlying agreements and obligations are merged into the consent judgment and cease to exist in any manner between the two parties to the consent judgment. So that leads us to the question, are set-offs allowed under the contract language of the consent judgment? What this court is tasked to decide is, in the context of this most simple of consent judgments as possible, whether the trial court abused its discretion, and yes, that is the standard of review for an objection to a garnishment, by not applying offsets to this consent judgment attained by Gante from other third-party sources that are not parties to the consent judgment agreement. As mentioned in argument by sister counsel, subsequent to the granting of the delayed applications for leave to appeal in this matter, while this matter was pending before the court, this court fortuitously had the opportunity to address this very issue of the availability of a debtor's claimed third-party offsets to a consent judgment in the published opinion of IGC FCO III versus one-way loans. IGFCO held that set-offs under a consent judgment are not allowed when, quote, nowhere in the consent judgment is it stated that defendants are entitled to an offset, close quote. Whether it was the UCC Article 9 process being applied to the sale in that case, or whether offsets of third-party rents from paid under an assignment of rents, those were not set forth in the consent judgment. They were not part of the parties' agreement. The IGC FCO case was extensively cited in my brief, along with all the precedential and binding decisions of this court and the Michigan Supreme Court on the issue of interpretations of consent judgments, and no reply brief was filed. No argument was made by the appellant on any of these contradicting binding precedents. Subsequent to the IGC FCO case, this court again addressed the issue of the interpretation of consent judgments in an opinion titled Prose, Prose versus Department of Natural Resources, docket number 368683, a 2025 ruling, where it again ruled that courts cannot read terms into consent judgments that do not exist. In that case, the Michigan Department of Natural Resources argued that the law of the state of Michigan on subdividing property should apply to the characteristics of the easements it agreed to with the landowner in the consent judgment. The court disagreed. The consent judgment was a resolution of a disputed litigation, and the restrictions in state law could not be read into the consent judgment unless they were included in the consent judgment's language. So regardless of what the restrictions of state law was, the state entered into an agreement, a consent judgment, without those restrictions, just like the parties in this.
I understand your argument. I guess you know the troubling part here, right? The troubling part is potentially that if your client collects on the life insurance, the malpractice claim, other payments, et cetera, you know, and that totals over 2.65 million, how much more can you also collect under the consent judgment?
Right. Well, I can only collect under the consent
You
judgment.
can collect a whole
The
2.65 million more.
2.65 million.
Right.
And interest.
Right.
Okay. What the court needs to appreciate is at the time this consent judgment was entered into, the idea that there would be any recovery under this judgment at all was highly unlikely. Mr. Benderoff was being investigated by the US government. He took the Fifth Amendment to every question in his deposition. Gross was not willing to pay any money. His insurance company, Admiral, took the position there was no attorney-client relationship. The Shoreline policy was almost certain to lapse because nobody was putting in money for the premiums. And Mr. Shoreline, it was undetermined whether he would pass away or not. And there was no criminal restitution to Mr. Gross because there was no criminal case filed.
Now there is, right?
And now there is.
So if your client collects the full amount of criminal restitution, how much can he also collect from the defendant?
The total that he can collect from this defendant alone under the language of the consent judgment is $2.65 million plus interest. He can collect other money related to his continuing outstanding obligation from William under the notes, because that is a separate and distinct agreement. The point that I was making, Your Honor, in going through that is at the time the consent judgment was made, Mr. Benderoff was represented by two of the finest attorneys in this state, all right, Mr. Cranmer and Mr. Gleason of the Miller Canfield firm, all right. He made a deal, and that deal was he was going to trade everything else, my client's ability to get interest, collection costs, all of that, in exchange for him being solely liable for that $2.65 million. Subsequent to that, all these things fell into place. Through my client's efforts, he was able to get money from Mr. Gross. The government got criminal restitution against him. The Shoreline policy paid. The criminal charges against Mr. Benderoff got dismissed. So now maybe he's going to get this $2.5 million that the government is holding under a forfeiture proceeding. But now, because all those things fell into place, he wants to come back and retrade the deal he made. But the deal he made did not have any setoffs. My client gave up rights under the note. And more
What was
important,
the value of those rights that you're claiming?
well, it would be all the interest for 3 years on $2.65 million at the rate that my client borrowed money from his securities account. All his attorney fees for the collection, okay, which were paid to me, had to be over $400,000 or $500,000. Okay. There were penalties for them not making reporting on how they were spending their money. They had to spend their money only on certain things, all of it coming to around $1 million, okay, extra, all right, because of that. That was bargained away. And this was the deal.
Okay,
And
so counsel, if I were to understand the way I look at your argument, you're saying, look, consent judgment, matter of contract, language of consent judgment, plain and unambiguous. We don't get to look outside the record about all this could have, would have, should have included. We look at the four corners of that document, no more, no less. If they wanted all the offsets, they would have included it. It's not in there. We're bound by that. There's no ambiguity.
that's correct.
Is that what I understand you saying? And then we're
Absolutely.
bound by the published decision that our court recently put out.
Right. You have to look solely at the language of the contract.
Thank you.
And Mr. Benderoff wants to be protected today from apparently a bad deal he made. But that was the deal he made. And at the time, my client gave up apparently approximately $1 million for him to make that deal. Well, now that the cards have fallen a different way, he wants to come back and say, no, I want all these setups, I want all these things that aren't included in the agreement. And his,
Just so I'm clear, in terms of of your client, is your client capable of recovering more than $2.65 million from Mr. Benderoff under any circumstances? My nature of my question is not limited to the consent judgment. I'm saying, can he collect more than that from Mr. Benderoff?
just with interest. He cannot collect more than $2.65 million with interest from Mr. Bentroff.
Okay. All right.
I think to your question, Judge Cameron, right? But he could collect other things on the original loan from the brother or from criminal restitution or other things.
Absolutely.
So he could collect overall 2.65 million plus say $1 million in interest and attorney's fees. Plus, I mean, I guess that's where I'm struggling. Like, where's the end?
The end is what he's owed under those promissory notes from his brother, okay, Mr. Gross, and the end is what he's owed from Mr. Benderoff.
So
But-
really what the argument is sort of different. It's a different argument if we're here, somebody saying, look, the brother, or it's procedurally different if somebody's coming here under those ancillary agreements, not the consent judgment, saying he's not entitled to this, call it $1 million under the ancillary agreements not arising out of the consent judgment because he's already been fully paid through the consent judgment.
Right.
It's a different procedural posture.
It's a different procedural posture because the key is this consent judgment is only an agreement between Mr. Benderoff and Dr. Gante. And all the notes and all the prior agreements and everything get merged and disappear. It's only this agreement. Now, if Dr. Gante had been part of this agreement and this agreement said they're jointly and severally responsible, okay, that's a different story. Because then what Dr. Sheldon's brother, William Gante, he would be a party that would bring money to that. But that's not our scenario. So there needs to be, if this court and the trial court realize this, if you're going to find that these offsets are allowed, you have to find a legal basis for it in the jurisprudence of this state. It's not in that one sentence, okay? It's not in the consent judgment, okay? So you got to look outside of the contract. And since it's contracts, what the appellant is trying to tell you is look to tort law and look to the idea of tort law and one injury, okay, and there being collateral sources that apply to that one injury. But that fails for a few reasons. Number one, this isn't a tort case, okay? There's no, body of law, common law that applies to this agreement. The only thing that applies to this agreement is the language of that agreement. So it's not a tort case, all right? There wasn't an injury and there wasn't an adjudication of an injury, all right? No one adjudicated that Sheldon Gante is entitled to X amount of money, okay? It was a settlement. It was a consent judgment, a contract. And when there is not an adjudication, and these were the cases I cited, okay, if there's not an adjudication, even under tort law, if you say tort law applies, the only way you can get the collateral source to offset that is if there's a jury verdict, if there's an adjudication by the court of the amount owed. And in this case, there is no adjudication. So for example, in the Gary versus Premier Property Management case, you had a situation where you had a case evaluation award. That's like a settlement. The parties agree to an amount by both accepting case evaluation. And the question was, could you offset against that case evaluation award? This is in the tort context. And the answer is no, because there wasn't an adjudication that the case evaluation award was the actual amount of the injury suffered. Okay, so in this case, the $2.65 million isn't the actual amount of the damages that Dr. Gante suffered. It was a compromised agreement. And when you have a compromised agreement, whether in contract or even in tort, if you have a compromised agreement.
Counsel, let me interrupt because I'm trying to square your statement earlier with everything you're saying is if the consent judgment subsumed all the prior agreements and it all came down into that, then how is your client then entitled to recover outside the consent and judgment on the basis of those contracts?
It assumed, it merged the agreements between the two parties to the consent judgment.
But it exists to all the other
But
parties.
it still exists as to my client's relationship with his brother, William.
Because they weren't involved in the consent and judgment that still exists as it applies to them.
Not only were they not involved in the consent judgment, but they weren't even a party to this lawsuit.
Understood.
Okay. So you can't have, when you have, to finish my thought, when you have a negotiated resolution, whether it's in this case, a consent judgment or a case of both parties accepting case evaluation, you can't do, even under tort law, a set off of a collateral source because there's never been an adjudication of the amount of the injury.
Understood. I think you understand that point. You understand that point? Yeah.
Okay.
Any other points you want to make on that? I think we understand the adjudication and the merger and all of that.
Okay. Nope. That's it. Thank you.
Thank you. Counsel, you have time for rebuttal.
I just wanted to address just very quickly this concept of how it's merged into the consent judgment. I don't think that can be the case. And I think Your Honor kind of touched on this a little bit. The consent judgment was entered in June of 2017. Sheldon Gante received amounts in the Shoreline Family Holdings in December of 2018. So, over a year later. And those amounts were specifically within that promissory note. So it can't have merged these all in. Otherwise, he would never have been entitled to the amounts underneath that promissory note that involved the Shoreline Family Holdings. The Shoreline Family Holdings, it was a $2 million life insurance policy. The testimony, again, it's not clear because we don't have very good testimony on this issue, but the testimony was that he obtained anywhere between $900,000 and $1.6 million on that. He was a 35%, I think, investor or whatever in this holding company. So that far exceeds the amount that he would otherwise receive were it not for that promissory note. So it can't have merged into, and then it's no longer in existence as a result of this consent judgment. Otherwise, he would never have been able to obtain those monies. So because of that, I think that's another reason why the amounts that he obtained from that Shoreline Family Holdings has to reduce the amount of the judgment. And just very, very briefly, I just wanted to touch upon the fact the case law that I cite in my brief, they're not all tort cases. In fact, the Great Northern case, it was a breach of contract case against a buyer and a competitor. They obtained a mediation award against one competitor, and they got a verdict with the buyer and a set-off applied against the verdict because, again, it was the same amount of damages that they were trying to recover from both. And that's exactly what we're trying to do here too. We have joint debtors that have the same obligation to pay for the same exact amount. They're not different in any way, shape, or form other than Mr. Bendroff has a consent judgment against him.
Any other questions? Any questions?
Thank you.
Okay.
All right, thank you.
Thank
Both
you
very well
very
argued.
much.
Thank you.
Thank you.
Very helpful. That case is submitted. Now moving to item number 10 on the 11 o'clock docket. Docket number 377006, Brown v. France. We had parties, counsel, both certified for remote oral argument. We received communication this morning that counsel for appellant was going to waive oral argument. Do we have counsel for appellee available, for Nulick? They waived also now? Okay. So that case, will be submitted on the briefs. And I had questions. We'll be left to our own devices. That moves us to the last item on our case call for today, item number 11, docket number 377629, In Re AJ Mackey minor. We have appellant is entitled and endorsed for 10 minutes of oral argument.
Good afternoon, Your Honor.
Good afternoon.
William Lancet, thank you for allowing me to do this. I'm going to make it short and sweet.
Thank you, Mr. Lancet. I appreciate being here. I'll note for the record, you're very lucky that some of my other colleagues here aren't here because they'd be all over you for not wearing a tie. But
The
go
reason
ahead.
why I had some surgery and I
Yeah,
can't do my neck.
understood,
Thank you.
understood.
But Your Honor, I'm asking the court to remand this matter. Look, this was premature termination. My client, oh, by the way, mother is present, Your Honor, with her adult daughter over there. She has sent me numerous information of her job, what she's been doing, the drug testing, the therapy. This should be remanded to get this back in front of the trial court. I've been doing this for almost 40 years. And let me tell you, it's rare that I've ever seen a referee when the prosecutor and the Department of Human Services come in and say, give this woman more time. We don't believe that we should terminate and go to a termination petition. He says, no, we're going to go to one. And so she goes to a termination petition. She pleads to the statutory grounds. Why she did that, I don't know. And this is premature. This is a constitutional issue. And she deserves the dignity to have her child back and to show to the court what she's been doing. I'm not saying that the record is perfect with her. She had her ups and downs. But even throughout that best interest hearing, she was doing things and coming around. And if this is remanded back, I almost would guarantee that the court would look at this, the lower court would look at this and say, you know what? This woman should not have been terminated. We need to give her some more time. Maybe she doesn't need any more time because frankly, she's done everything. So I think it's premature. It was a premature termination. One other issue is if the court does a published opinion to consider adding to the In-Way White case, the Olive White case, a factor to consider other custodial arrangements. But I really think this needs to be remanded.
Counsel, were you?
This amount of information.
Yeah, were you counsel below as well?
I was not.
Okay.
And I guarantee you, if I was counsel below, I would never have a client plead to the statutory grounds for termination. Because once you do that, you have very little to work with on appeal.
Would you agree that some of these constitutional issues you raise were not preserved below an appeal? And so we're stuck with not stuck with, but we're required to apply the plain error rule. Is that correct?
I agree, but Your Honor, let me just make a thing. She already has constitutional protections. The U.S. Constitution and the Constitution of Michigan already give her a liberty interest in the care and custody of her children. She's got that, aside from a standard of appellate review. And so I look at this, and maybe the court should too, is, okay, maybe it's plain error. I think even if it was plain error, I think you're going to find a mistake was made. But she comes in here clothed with constitutional guarantees. And so whether it's preserved, I'm not so certain, because you're arguing that her constitutional rights were violated by a premature decision to terminate. And she comes in there cloaked with this. I'm not asking to give her constitutional rights. She already has it. And I think there's an issue with the standard of review with that. But having said that, it almost doesn't matter what standards you use. I think you're going to find a mistake was made. This is what she's presented to me. This is amazing.
But counsel, isn't the difficulty we face on the review that there was some stipulation and finding at the dispositional stage?
The only stipulation is that she unfortunately pled to the statutory grounds.
Right.
I probably should have raised ineffective assistance to counsel, to be honest with you, but she pled to the statutory grounds. That gave the court ammunition, and once you get there, it's awfully hard. I think I've had a few cases in my career where we got to best interest where we didn't terminate. But there's few and far between because the statute says you have to do it unless you find it's not in the children's best interest. But she was even at that point doing things and still complying. It wasn't perfect. I had cases gone on for 2 years, haven't done as much as she did. Wasn't perfect, not saying that, but I think the court should look at this because she does have those constitutional clause attached to her, that it should be remanded back to consider the information that was presented to me, that she started actually at the trial and has continued here today. And I get very few clients that actually come to these, are invested themselves, that actually want to come here and hear what's going on. And plus, it's a relative placement, so that does weigh against termination. This was not a foster care placement. So, you know, it's just,
She
it
was,
shouldn't be
counsel,
it should
she
be
was
remanded.
afforded
Yeah.
a hearing in front of a referee, and evidence and testimony was brought in during that, right? Then the issue, as I understand an appeal, is she wanted more time to comply with the.
And that was raised in the trial court, correct?
Yeah, okay.
And I raised that in my.
What about, do you take any issue with the other best interest factors other than the time to comply?
Well, my issue was that perhaps the court might consider adding a consideration, other custodial arrangements
Other
that were
custodial
made.
arrangements?
I mean, that's up to you, Ron. That's up to you, you know, to what you want to do. But at this point, I mean, that would be great if you clarified it or added that as another requirement. But I think constitutionally and what is right here is to send this thing, is to send it back and let her show what she's done and see where it goes. But it just was a very premature termination by the referee. I think he committed a clear error of law. I think he abused the discretion, frankly, in ordering it. When nobody else was sitting, when nobody else was before him saying, do the petition. Thank you. Thank you very much.
Any questions?
What were you holding up those papers?
Oh,
I
this
didn't
is
understand that.
this is the information my clients provided me of what she's been doing since the termination.
Oh, okay.
Oh, so compliance with.
Right,
Whether
this
it's
is on her own.
counseling and treatment and all
Everything
those things.
on her own and
Oh,
employment. You got a
post
glowing letter from her employment.
Right.
She got her daughter here, another daughter. So that's what was
So,
provided to me.
Let me just ask you, because you did raise and you referenced it again at the end, consideration of relative placement or guardianship. Can you point to us any authority, case law, or anything that grants us the ability to include that into?
No, but you did do it in that Olive Metz case. You did put together, the Court of Appeals did put together.
I didn't do it.
No, not you. But the Court of Appeals put together a list of factors to consider, and that was not one of them.
Can you slow down and tell me that case? I don't have
Oh,
it in
yeah.
front of me.
Well, let me look it up here.
This is that considering a relative placement is a factor to be considered and whether.
Yeah,
Olivet's.
In re Olive Metz, 297 Mishap, 35-2012. Well, it's a published case, and you put together a group of.
297 Mishap 35 in 2012.
2012, yeah.
Okay.
And-
All right.
and that's
I just
ca-
want to make sure we're considering everything.
Thank you.
that
And
you're
that
saying.
case has been used by jurisprudence, but, you know, I think a factor is missing in that, in my opinion. But if you put together that list, you can add to it if you choose to do it.
Understood.
So thank you very much.
Any other further questions, Judge Levinson?
All right.
Judge Campbell?
Thank you.
No, nothing further. Thank you.
Good afternoon, Your Honors. Joshua Miller from the Oakland County Prosecutor's Office Appellate Division on behalf of the petitioner appellee Department of Health and Human Services. We're asking the court to affirm the order terminating parental rights in this case. To real quickly address the point that was made at the very end of counsel's argument, Olive Metz did include relative placement in the list of factors that can be considered, but it did so because it was compelled to do so by statute. So what counsel's asking for to just pull out of thin air, add a factor, is not what Olive Metz did. It was compelled by statutory text. But be that as it may, in this case, there was testimony at the best interest hearing about why a guardianship would not be appropriate. So even if the court was to go down that road, the only evidence before the trial court when it made this decision was this is not an appropriate type of placement for this child. Beyond that, I would just rest on my brief largely, unless the court has specific questions for me, because the record that the trial court had before it was what had to make the decision on whether mother would continue and perhaps continue services on her own and then actually finally show benefit from them was a roll of the dice at that point, based on what the court had in front of it.
Can I ask a practical question based on appellant's counsel? I understand we have his client and a daughter here, an adult. Is any of this moot? But in terms of an adult child now, is there anything that would moot any of this?
I think that it's a different child, not the child who's.
Okay, that's what I
Yeah,
was,
no.
that's what I was just clarifying, like the practical piece of it. That's
Yeah,
what I wanted
no,
to
this
make
was
sure.
this was a 3-4, this was a very small child
Yeah.
who was at issue here. So
Okay.
nothing would be moot there.
Gotcha. I
Um,
want to make sure I understood the factual background.
Understood. But unless the court has any specific questions for me,
I have one, which is, I think, opposing counsel mentioned that everyone at the court said, hey, give her more time, and yet the judge didn't do that. Is that?
it's something he is allowed to do. He was looking at.
Who's allowed to do?
The referee, or I guess because it was
Okay,
a
but-
referee, not not a court, a judge.
You're representing DHHS, right?
Correct.
Functionally. Do you agree that that was the posture, not that the referee couldn't have done what he did, but do you agree that that was the consensus among kind of the parties?
At that time, it was.
Okay.
And then when he ordered the filing of the petition, then it became our burden to go forward with that and
Was that-
sustain the burden.
That was at the best interest phase?
No, this was, there had been the initial pleadings, there was the disposition, and then because this was not an initial, a termination at the initial disposition. So there was the disposition, it was services were ordered, and then when in the referee's estimation, respondent mother was not making sufficient progress, he orders the filing of a supplemental petition. At that point, then it becomes, the goal is termination. And then we as DHHS have to sustain the burden.
And that's the statutory grounds.
Statutory grounds, which were pled to, and then best interest.
Because I thought appellant's argument was that there was an error in not considering, in giving her more time or considering relative placement during the best interest phase, and that your opposing counsel said that everyone agreed, even at the best interest phase, that was appropriate. You're saying, no, that was true earlier
That was
on,
earlier
but
on.
not at the best interest.
That was prior to the filing of the supplemental petition.
Understood. Thank you for
Yes.
clarifying that.
Are there any other questions from the court?
Counsel, you have time for rebuttal if you'd like to address anything?
I really don't. I just asked again. I think the representations made by brother counsel is accurate here. It was in one of the hearings where it was discussed to give her more time, and that's when the referee said, no, go ahead and file the petition. And then the ball gets rolling after that. And even at the best interest hearing, it did come out, even the referee acknowledged she was doing things, but it wasn't enough, but she was all along doing things, not the best, but she was. And I think it's just a premature termination. I think we need to be very, very careful when we're looking at taking away a child from a mother, that the safeguards in that proceeding comport with all of the constitutional guarantees that she has and procedural due process. That's what I'm asking the court for you to take a look at. Thank you for your time.
And so I want to just pause you there for a minute, because I agree with you. It is a very serious
Yes.
matter. And one of the things we've taken issue with as a bench is sometimes DHHS, and you can take, not you personally, but I hope you take it back to your bosses, that sometimes we get late briefs. Sometimes we don't get any briefs at all from DHHS in these matters. And it hinders our ability to fully vet and evaluate these decisions. So I strongly encourage DHHS to do that. To your point, what I'm asking, my point is, what procedural safeguards, which are extremely important, were not met, or where would be the error? Can you cite the specifics other than what I see as an argument that the recommendation and the decision below, the discretionary decision below, that failure, the time had passed to fully comply with the plan? And so what's the procedure besides that discretion, which the statute gives, right?
Because the court erred in not granting her additional time to get reunification in place. They could have given her, it would have not changed anything. The child is not in foster care, would have given her an opportunity to present additional evidence, and the court would not do that. And I believe that's the error, that's the procedural error that cut her at the knees, so to speak, and cut her liberty interest in half. If you would have given her more time, 3 months, 1 more month to present it, you might have had a different outcome here.
And is there a case that you can cite to us that says the failure to give that more time is a plain error requiring
Well,
reversal?
I don't have a case in front of me. I have one now that's pending in the Michigan Supreme Court that's almost going to remand it. We did briefs that addresses that issue, but they have not come down with the decision. They sent, it was application for leave. They sent it saying, we want you to answer 2 questions. One of them is reasonable efforts. The other one is time. And that's what we're working on now.
Understood.
And I will say that the Court of Appeals and the Michigan Supreme Court has really done a great job in paying attention to the body of law that's coming out in these cases. And your opinions, whatever you do, your opinions are well done and well thought out, and you give a lot of guidance to the bench and bar. So you're paying great attention to it. And I hope that the procedural safeguards in place of getting more time, hope that this court adopts it. And thank you very much for your time and have a good day.
Understood. Thank you for your
Thank you.
arguments. Thank you for raising these extremely important issues. Both sides very well briefed, and we take these things very seriously and review the record thoroughly. Sometimes we're bound by our precedent and the standard of review, but we're certainly going to take a look at everything you've presented. So thank you very much. With that case will be submitted, and that concludes day 1 of panel number 3 for the May 26th Detroit case call.